The first is that our host institution is celebrating 40 years since it was established this year, so it coincided with that. We were told it's a premier institution with a premier legal education program, starting also a master's program soon, and I'm one of the testimonies of that quality education. I was born and bred here education-wise. Then we were also told that this conference is happening hot on the heels of COP29 in Baku, Azerbaijan, where a lot of climate justice and climate change issues were discussed, resolutions. I'll mention them very briefly. And then thirdly, we heard from the LSK representative who represented the president that this region and 6 other counties are what are normally known as the breadbasket of the country. And it's befitting that we are talking about climate change and livelihoods in this place. So, on to the momentous occasion. The first point, Baku. We had a lot of presentation on what happened in Baku. We were told that there were some failures. We didn't secure enough resources to combat climate change. We were told that the transition to fossil fuel there was not unanimous agreement. But also we were told that there were some gains from there. There is agreement that we need to build climate resilience. There is recognition that we need to have inclusive processes in climate governance. And there is also positive message that came out that collectively, as this region and the developing world, we can actually have a countervailing voice for climate change. So the conference, we were told, is unique, and it will determine the future of COP conferences. But more importantly for us here, and because this is happening so close to that, it was said that the discussions here, because whatever is discussed in Baku, the CITES of implementation is here, and this is one of the very first forums to do that. Then the judiciary, and specifically the Environment and Land Court, that is the main convener of this conference. It came out that through various speakers that the ELC has been very proactive in its mandate, not just in adjudication, but also in promoting the understanding and appreciation of what the court is doing. The court is one of its own unique kind, and we heard that the influence is going across the region and the globe. The presiding judge mentioned about training of judges in China. I was surprised. And it just shows that growing recognition and significance of the court, and that many other examples are being carried out in different jurisdictions to copy what the ELC is doing. And of course, ELC is part of the judiciary and the justice sector. We heard about the greening justice sector and the commitments which have been made. The judiciary actually committed to reduce use of paper by half by 2025, 2026, and many other targets to ensure that the judiciary is a greening environment for this. And then together, the judiciary, the Judicial Service Commission, and the justice sector generally, we acknowledge that the growth of the number of judges in the ELC, from an initial of 12 to 52 judges in 40 stations across the country, is beginning to have an impact in terms of resolution of disputes, and of course, around the environment, the land, and the areas that the court is touching. And of course, we heard that even the case clearance rate is above 100%, which is a very efficient way, and we were told there's a clear strategy of clearing the 12,000 cases which are now pending in the court. The judiciary also was informed to take advantage of the potential investments, including in greening, so as to boost their revenues, and some of the partners like CPF are ready to assist the judiciary. So apart from the institution, then there's also the theme now which came very heavily yesterday, which is a just transition. And this year we are told, as we transition, as we build climate resilience, as we adapt, as we mitigate, we need to carry everyone on board. Virtually every speaker who was in this podium mentioned something about that. And they started by talking about the damages, the negative effect, and how it affects the most vulnerable groups in our communities. And therefore, that is a call for us to ensure that no one is left behind. And with that, the rallying call for many of the speakers was that it's a call to action, and it's action that must replace rhetoric. Then we were told that in order to have this just transition, and we spoke about distributive and procedural justice, where the benefits from climate mitigation and all that should be shared fairly, and of course in procedural that every voice, including those of the most vulnerable, are heard as we make decisions. And because it's the ELC, we were told that the role of the court in this context goes beyond just mere adjudication to being part of those outcomes that we expect, apart from cases that the judges are conscious of that just transition, and it's incorporated in part of their decision making and the active promotion of mandate that we have seen. In the breakout sessions, we had public participation, and in this, there were very good presentations on what should change. What came out clearly is that the frameworks are already there. We have them at the global, regional, domestic. And even though we have a substantive act that is in the process of being drafted and enacted, we have laws which deal with aspects of public participation, including the Constitution, and that in terms of adjudication, there's enough principles to refer to domestically and internationally. However, it was mentioned that because of some of the concerns, such as inclusivity, diversity, including traditional knowledge on climate mitigation, including traditional governance systems in the justice systems, their participation, we need to incorporate those in a substantive act. And one of the core recommendations from here was that we need to speed up the enactment of the Public Participation Act to cater for this and to seal some of the gaps which still exist. One of the issues which was mentioned for reflection during this session is there is a clear public voice on issues vis-a-vis policy proposals. Is it maybe time that public views which are expressed clearly on an issue, is it time for them to trump policy choices of the government? Can policy choices actually go against what the public has clearly mentioned in public participation? So moving the debate to that level. And then the other theme that came out clearly is learning from others. And this is, of course, with the courts in their adjudicatory work, but also in knowledge sharing across the board with all other agencies. And here, for the court, very progressive jurisprudence was mentioned. For instance, the Hague District Court in Netherlands, which has issued a judgment that the Shell company should reduce carbon emissions by 45% by the year 2030, and they use the Paris Agreement to reach that. In Australia, the Minister for Environment has been told that he has a duty of care in terms of climate change and climate justice. The rules of litigation in the US were very difficult between 2002 and 2015, but they are now relaxed to allow accountability of corporations. And this conference is an opportunity to share the further knowledge and also to network and ensure that we have a cohesive discussion. But apart from what is happening out there, mention was also, we also had a mention of our own very progressive jurisprudence from the ELC. And this includes things like the court judgments on the lifting of the logging ban in forests. I'm sure you're very familiar with that. We heard about the Mau Forest land preservation. We heard about green sentencing, where sentencing is done in terms of where some category of offenses, someone is sentenced to maybe plant trees, take care of the environment. We also heard about the role of land management, for the role of management bodies in zoning and private rights, balancing those, especially in land which are ecologically sensitive. There have been judgments on that. What also came out is that climate justice, climate change is very cross-cutting. And we heard that there is a relationship between climate change and work. This came from the representative of the presiding judge of the ELRC, the Employment and Labor Relations. Climate change impacts the nature of work. It affects productivity, disaster preparedness at work, and the need for just transition in the workplace. So you can see, even from a point of jurisprudence, it's not just the ELC, but indeed all other courts that should focus on these issues. Still on collaboration, I talked about the ELC and jurisprudence, but institutional collaboration. We were told until 2 years ago, the National Treasury had nothing to do with the ELC, but from 2 years coming, we have seen through under the FLOCA program, there's been a lot of collaboration, which including this conference here, and it shows the need of collaboration between courts and other institutions in order to have that uniform agenda that we are talking about. There was the breakout session on sports and climate change. It very clearly came out that there is need to have a clear agenda for the global sport community to combat climate change and to also adhere to standards such as greenhouse gas emissions and all that. And more importantly, because sports is a very visible event, it could be used as a tool to create solidarity among global citizens for climate action. The other point that came out very clearly is what I'll broadly name technology and climate change. And here we had a session on artificial intelligence. And if you're looking for a definition of a very simple definition of what artificial intelligence is, it came out in this session. It's data and machine brought together and analyzed. So data, machine, giving information. So some of the issues that came through here is that technology is very enhancing, where it creates efficiency and all that. But also there are risks with this technology, and specifically with the AI. We need to use locally relevant data for machine learning for more effectiveness and targeting. For instance, we need to remove bias from the language that these machine learning they use and data. One which targets, for instance, vulnerable and marginalized groups through AI and all that. There's also a general caution on the limit and risks of AI, and there's need to put in place guidelines and measures for use of for appropriate use of technology and mitigate those risks. Beyond AI and decision making, there was mention of use of technology in food production and support to farmers, identifying fertilizer use, its market information on various products for farmers, using mobile phone apps, and all that. And there's also use of use of technology to monitor disaster, like for instance, forest fires, but also even KFS. It was mentioned, I saw that in the notes, that they are using technology to track the growth of the population, the tree population, with regard to the targets which have been set by the government on the number of trees to be planted in the next 10 years. So in very brief terms, those are the discussions that we had yesterday in the opening sessions, in the high-level panel, and in the 3 breakout sessions that we had in the afternoon. As I finish, I must say that I will not do justice to the amount of information and knowledge and ideas that were shared through these programs for the few minutes that I'm here. But I believe that brief capturing gives us space for the discussions today, and I wish you well in this second day. Thank you very much.
A round of applause for Bosire. Please, let's clap for him. I know he can't finish everything, but I hope that we can have the report out so that we can actually begin utilizing some of this. And of course, we are going to have a very good session on resolutions tomorrow so that we see what action do we take from here onwards. Thank you very much for coming. We were trying to see if we could have everybody on board. Because this book of Revelation, ELC, we don't want to do it when people are absent, then they'll say, oh, why did you show it and I was not here? So are we all here now? I think a few key takeaways, and I'm looking outside. I see some of us are still outside. Can we please come in? Very good points on financing that came yesterday. Very good points on technology. Very good points on capacity building. The use of technology, AI. I think we have very many points that we must take home as ELC. And I think we have capable judges, magistrates, courts that have shown that we can actually do more than what we've done so far. And for that, I would like that we invite ourselves to watch a very short movie. It's actually a breakdown of some book that was shared with us that we thought we should share with all of us just to show the journey. These are the 52 judges of the Environment and Land Court, and Hongera for making time to come to this conference, but also for the hard work. So let's take a look.
Kazi ya watoto kweli kila siku ni kucheza. Tulikuwa vijana, tulicheza na masomo. Uongeze pia mwisho wako utapata kazi nzuri sana. Someni vijana, muongeze pia bidii. Mwisho wa kusoma utapata kazi nzuri sana. Waliokosa kusoma wafanye kazi na nguvu. Watoto wa kusoma kweli waliokosa kusoma wafanye kazi na nguvu. Waambie watoto mwisho wa kusoma kweli furaha. Someni vijana, bidii. Mwisho wa kusoma utapata kazi nzuri sana. Someni vijana, bidii. Mwisho wa kusoma utapata kazi nzuri sana. Siku hizi sikupigana magumi, kalamu na karatasi ndiyo silaha ya siku hizi. Mambo ya siku hizi sikupigana magumi, kalamu na karatasi ndiyo siku hizi. So muongeze pia bidii. Mwisho wa kusoma mtapata kazi nzuri sana. Someni vijana, muongeze bidii. Mwisho wa kusoma mtapata nzuri sana. Tulikuwa vijana, tulicheza na masomo. Kazi ya watoto ni kucheza. Tulicheza na ya watoto, kweli kila siku ni kucheza. Someni vijana, muongeze pia bidii. Mwisho wa kusoma nzuri sana. Someni vijana, muongeze pia bidii. Mwisho wa kusoma mtapata kazi nzuri sana. Waliokosa kusoma hazina nguvu, waambie watoto sio wa kusoma kweli furaha. Waliokosa kusoma wafanye kazi, waambie mwisho wa kusoma kweli furaha. Someni vijana, muongeze bidii. Mwisho wa kusoma mtapata kazi nzuri sana. Someni vijana, muongeze pia bidii. Mwisho wa kusoma mtapata kazi nzuri sana. Vijana tulicheza na masomo, kweli kila siku waliokosa kusoma wafanye kazi, mwisho wa kusoma kweli furaha. Vijana muongeze pia bidii, mwisho wa kusoma mtapata kazi nzuri sana. Mambo ya siku hizi sikupiga na magumi, kalamu na karatasi ndiyo silaha ya siku hizi. Mambo ya siku hizi si magumi, karatasi ndiyo silaha ya siku hizi. Ni vijana muongeze bidii, mwisho wa kusoma utapata kazi nzuri sana. Ni vijana muongeze pia bidii, mwisho wa kusoma utapata kazi nzuri. Kuwa vijana tulicheza na masomo, kazi tu kweli.
Some of us are not here yesterday. We want to welcome you to the session today. And with this, I would like to invite Dr. Wambua Kitugu, our moderator, to take us through this session. Let's try to keep time a little bit so that we save on what we've already lost. Welcome, Wambua. Thank you.
Thank you. And yeah, thank you for playing those clips. We've not only seen the names, the photos of the honorable judges, but I've personally got to know their M-Pesa names. I don't know if that's useful information, but yeah, what I do with it is up to me, right? All right, so welcome to this session. The theme of the session is on climate finance. And we'll be trying to situate the role of the ELC in promoting access to climate finance. Right, but so before I introduce the panelists, it's also good to give some little background to the theme. So climate finance means many things to many people, but in a nutshell, it's the finance that is required to support mitigation and adaptation actions, but also promote equity through compensation of those who've been impacted inordinately by climate change. And yesterday, Dr. Odengo told us it's also the means of implementation of the climate change agreements. So the global status of climate financing, we had been promised $100 billion per day, per year, at the signing of the Paris Agreement. But as at the year 2021, the Global North had collectively provided 89.6 billion for that particular year. So meaning that the promises of climate financing had never been fulfilled. But there are several mechanisms which have been established to facilitate access to climate financing. There is a Green Climate Fund, which is under the custodianship of World Bank. And in the current cycle, countries have pledged 12.8 billion out of the pledges that have been made, yeah? So under Loss and Damage Fund, there are pledges of $792 million, though the fund has not been operationalized as yet. The Adaptation Fund is also another mechanism. It now has $187 million in terms of pledges. Then there's a small one called LDC's fund and Special Climate Change Fund, $179 million. But this money is not enough because globally, African countries estimate to spend about 1.76 trillion US dollars per year on financing their NDCs. And Kenya estimates to spend annually $4.39 million per year. Yet the country is only able to raise internally 1.5 billion US dollars. So that's about 35% of what we need to implement our total climate actions. But that notwithstanding, Kenya has been very active in soliciting climate finances. Like for instance, in the Green Climate Fund, we are among the top in Africa in accessing, so far when I checked their website, we've accessed $5.7 million in the current replenishment round. From the Adaptation Fund, we've accessed $9.9 million. From FLOCA, we've accessed $56 million. But that notwithstanding, our government, through its climate-related investments, we're only able to raise 55% of what we need as a country. So that shows, despite the promises that I've made, despite the huge need that we have, there's still a gap in terms of getting the finances that we really need as a country. So today's panel will be looking at those issues. How can we, on one hand, accelerate access? On the other hand, how can we also foster equity in the utilization of these funds, particularly for the vulnerable and most marginalized in our society? So the first panelist is a distinguished legal scholar. She's currently the Director of Law Division of the United Nations Environment Program, a heartbeat away from being the Executive Director of UNEP, 2 or 3 heartbeats away from being the Secretary General of the United Nations. She is a senior counsel of the Kenyan Bar. She has taught in many universities across the world. She has also sat in boards of distinguished environmental organizations in Kenya and abroad. She holds a doctorate and master's degrees from Stanford University, a higher doctorate from the University of Nairobi, a master's degree from Warwick, and a bachelor's degree from University of Nairobi. Please, let's welcome Professor Patricia Kameri-Mbote to the podium. I forgot to say she has taught many who are here, who are serving in our judiciary, many in academia, including yours truly. So, karibu, Professor. Our second panelist was introduced to us yesterday. A very stellar career in public service, and currently the head of FLOCA, but also the head of African Negotiators of Climate Financing, Dr. Peter Odego. I need not add more to what was said yesterday. Karibu. Our third panelist is currently the CEO of Nuclear Power Energy Agency, NUPEA. He's also Kenya's National Liaison Officer to the International Atomic Energy Agency, holds a Bachelor of Laws degree from this university, and a master's degree from the University of Nairobi. He's an advocate of the High Court and a CPS as well. Please, let's welcome Mr. Justus Wabuyabo, who will be stepping in for the panelists from the World Bank. Karibu sana, Mr. Wabuyabo. Our fourth panelist, unfortunately I didn't get a bio in good time. He is the head of communications at NetFund. And as you know, NetFund is a state corporation under the Ministry of Environment, Forestry and Climate Change. So he's standing in for the CEO, Mr. Hassan Sheikh. Karibu. Then the last speaker, or panelist, is currently the head of Women, Peace and Climate Action in Africa. She's a distinguished practitioner in peace and conflict matters, has consulted for many organizations in Kenya and globally. And her last public position was the CEO of NCIC. So allow me to welcome Dr. Skita Wangeshi Ocharo to the podium. All right, so quickly, so we start with Professor Kameri Bote. Climate financing. What is the role of UNEP in facilitating climate financing for African countries? Just to start with. And secondly, from where you sit as the director of the law division, what role do you see African judiciaries playing, and in particular, our ELC, in promoting access to climate financing for our people?
Thank you very much, Dr. Ombwa, and I am very happy to be here. I think the issue of climate financing has to be looked at from a global perspective, the gravity of the problem that we face. I think if you look at the reports that have been coming out on a changing climate, you will see that this year is the hottest year in history, not in a decade, in history. And you will also see that the countries that are most affected by climate change are really the poorest, and also the ones that have contributed the least to climate change, which means that the burden of climate change is felt inordinately by developing countries and small island states. And when we then talk about finance, one again has to go back to the genesis of the climate change framework in 1992 in Rio, where it was agreed that climate change is an issue of common concern, one, but also that all countries have common but differentiated responsibilities. Common because we all need to deal with climate, because it doesn't matter where the anthropogenic gases are emitted. They affect all of us in the same way, and like I've said, affect even those who are not contributing to emissions more. And what this catalyzed was a flow of resources to developing countries and small island nations, not just finances, but also transfer of technology. So if you look at the architecture of the climate framework, you will see a very deliberate attempt to bring finances. And this is through, for instance, originally the Global Environment Facility, which is now working on the 9th replenishment. The other funds that Dr. Wambua talked about. You will also see that there is what they call the Climate Technology Network, where there is brokering of transfer of technology to developing countries. And if we look at, I think if you look at resources we need for climate change, the $100 billion that was agreed at Paris in 2015 has become more and more dwindling. And maybe it's also encouraging to note that in Baku, it was agreed that these would be tripled. But even tripling means that the needs are becoming more and more. Why am I saying this? I'm saying this because there is a role for the judiciaries to play. And we have seen judiciaries in other parts of the world demanding more from governments, so that if money comes in, administratively, you can look at whether the actions that are being taken are actually adequate. And you could even move in to look at, is there allowance for resources for adaptation? For the longest time, we were talking about mitigation, and now it is clear that adaptation to climate change is very important. And strong institutions like judiciaries can actually play a role in ensuring, one, that resources are availed where they're needed, and more fundamentally, in ensuring access to justice for those who are affected by climate change. And access to justice can benefit from resources. Thank you.
Thank you, Professor. I think two important points there for the judiciary. Ensuring that resources are availed, so when litigants come to court seeking orders to compel government to do more in terms of ensuring climate actions are funded, then that's something that can be done, but also providing access to justice, yeah? But then Prof has also given us the broader context of climate financing globally. But then I always wonder, if I go to Machakos, I come from a small village called Jarvis, yeah, in Machakos. And I tell my grandmother that Kenya is receiving money, climate financing. How will I convince her that for sure my small village, Jarvis, we are getting the $56 million through FLOCA, 9 million through GCF, several millions from other. Jeff has also given us a lot of money through UNEP. So how can I convince her that this money is really reaching the ground? And that's why we need to hear from Dr. Odengo, how has FLOCA contributed to addressing challenges of marginalized communities who are facing inordinate impacts of climate finance? Is this money really reaching my grandmother in Jarvis? Please, Dr. Odengo.
Yes, thank you very much, Mr. Moderator. It is true that the money is reaching your grandmother in Jarvis. The only thing is that you do not go there to support your grandmother on how to plan for that. So, and it is very, very important because my grandmother, with the challenges that has been spoken here by Professor, climate change is very complex to you, to me, but climate financing is more complex to everybody, including those who have done economics, because climate finance is not this money that you see around. It is money which is over and additional. Over and additional means that your grandmother and my grandmother need to be able to be told part of this money is money for business as usual. So this is not finance, climate finance. But this is climate finance because it is over and above what you are entitled to. This is now where the judiciary comes in with awareness, with knowledge, and with fairness, but the access to information to differentiate between the two is fairly provided to my grandmother. Two, it is at that time that we now need fit for purpose action. When we designed the FLOCA 3 years ago, we had already gone throughout all the 47 counties, all 1,450 wards, all villages, to know what are the gaps. From that gap analysis, we had to start designing a program fit for purpose, not for Peter Odengo, but for the worst, the most vulnerable, not a border person. Border person is strong, can run with the border to help Kuche. But my grandmother will not jump a flooding river. It is on that account that this program takes a number of factors into consideration. One, the design makes the most vulnerable people within the society that you require to show within the minimum access conditions. There is what we call minimum access condition. Before you get even to minimum access condition, there is what is called readiness. So the readiness, you have to be ready to get into this money, but readiness is now where you can remember that we have been going around and insisting that each and every county must have Climate Change Act as provided for in the Climate Change Act 2016, which requires all the counties must now develop their own act to normalize or to localize their local action, because climate change is a localized action. You have been reading, if you are following this SAS, it was only 2 counties that were giving us problem, Mombasa and Nairobi. Mombasa came in, the pressure was too much from my grandmother. The governor could not attend any meeting. Whenever he goes, he asks, where is he, pesa ya flock? Iko wapi? Wacha hii. So they did it, and then Sakaja also could not move. Last month, Sakaja signed that act. That means that that is the starting point of ensuring that the resources which are finite reaches where it is needed. The third one is that there is what we call the criteria for accessing the money. 50% of FLOCA money, first of all, is given equally to everybody in the 40 whatever, 50%. So it means that fairness, equity, and effectiveness is already catered for, 50%. Then the balance of the 50% is now being distributed based on the performance, P for R. You have to deliver, you have to demonstrate that you are able to use this climate finance resources to add value to that. And that adding value means that the FLOCA program team, where I come from and with my team, we do not do two things at the same time. Division of labor. The Office of the Auditor General comes in, we give them those conditions. These are minimum, this is pre. Those, if you are not pre, you don't get in. When you get in, then you get the minimum. But what are the minimums? Now, there are three, very simple. You have to demonstrate and dedicate that you allocate at least 1.5% of your development fund. Because everybody, the government gives you money. Part of that money is supposed to address climate change. So every county needs to demonstrate and to allocate that money. First of all, it is from their own resources, local circumstances. So if you don't allocate that, then automatically you are out. What does that one mean? That you don't believe in building the resilience, you don't believe in building the adaptive capacity of my grandmother. You don't also, it means that the money which comes from the exchequer, which is part of it, normal climate also included, you don't declare it to the people. So we get you out. Fairness. Then once you've demonstrated that, then you are supposed now to take that money into special purpose account, SPA. And that SPA is provided for within the County Climate Change Act. Within that act, it is provided that you have to establish climate change fund. Why this? Because of corruption. Money is fungible. Once you get money from my friend and you mix them in a pot, 100 shillings is 100 shillings. And this is the loophole where smart guys and ladies around confuse my grandmother. So immediately you declare that that money is taken away to a very special purpose account. This special purpose account is monitored through the satellite. You cannot withdraw. And then finally from there now, for you to go to the next level based on the money which is being allocated in your committee, County World Climate Change Planning Committee, at least 30% should be women, at least there should be indigenous people. I'm an indigenous, I eat samaki, it must be represented. Children need to be, youth need to be represented, at least 30%. And then the other 30% is left for the professionals, where you and I, we are always missing because we are very busy. Yes, so your allocation is always not taken. So now we look at those one, and then now those one now scores to about 60, and then each score is equated with the dollars, and then it's millions of dollars. So each county has already been given an average of $1.25 million per year for the next 3 years continuously, because climate change requires that you have to provide money in 3 ways. One, it must be sustainable. Sustainable means it should be there today, tomorrow, and many years to come. Number two, there must be ease of access of that money. Number three, it must be available in scale. So these scaleness, so those are coupled with the three. But then, how then do we do this one for the judiciary? Because things may not. It needs a strong judiciary. It needs a strong land and environment code. It needs those people with the understanding of the global systems of climate change, so that that man who is coming with carbon credit, that I will give you a carbon credit, it is the code where people are going to having hope, so that there is differentiation. But how do you reach there? It is us to support you. Thank you.
Thank you very much, Dr. Odhengo. I think he has given us a layout of how FLOCA operates, yeah? And in my understanding, FLOCA is like a carrot that's supposed to stimulate and incentivize our governments at both levels to invest a little bit more on climate actions, yeah? Set up frameworks for that. And he mentioned something about readiness, that a country has to be ready for climate finance. And there was a report that showed Kenya was ranking 149 globally in terms of readiness in 2019. I don't know if that has improved. And also in calculating readiness, do you just look at the executive at both levels, or do you also extend the assessment to other organs? Is the judiciary required to be ready for climate financing? So hold on to those thoughts, and in your concluding remarks, I would like to hear a little bit more on, judiciary, how, as a state organ, how can it better stand to access finance in order to discharge the onerous responsibility that Professor Kamori Mbote mentioned. So now, let's listen to Mr. Wabu Yabo, the institutions that are now meant to implement actions, climate actions. Now, nuclear energy, even though it has been touted as a response to lowering emissions, there are always concerns about its environmental impacts. Now, Kenya has embarked on a journey towards generating nuclear energy. So first things first, Mr. Wabuyabo, we want to know, when is Kenya generating the first megawatt, not even megawatt, the first volt of nuclear energy? Are we on track? So when do we need to see that volt get into our grid and ultimately into our households? But then also, what strategies has NUPER put in place in order to access climate finance, in order to finance your ambitions to make Kenya a country that has nuclear power? And then lastly, how are you handling these issues of concerns over environmental impacts and the risks that come with nuclear energy? And where do you see this court playing a role in addressing all these issues? The financing on one side, the impacts on the other side. Karibu.
Yeah, thank you very much. First, maybe just as a way of background, when a country, what the IEA calls a newcomer country, wants to introduce nuclear into their country, the IEA, which is an international organization that guides or looks at the issues of nuclear across the globe, has come up with what they call the milestone approach. So there are three critical stages that a country has to go through before it can deploy the first nuclear power plant. And the reason for that is obvious because of the safety and security concerns that are around nuclear. So the first step is really about a country being able to make what is known as a knowledgeable decision to go nuclear. And at the end of that, you attain a phase, which is now that you're ready to start the process of preparatory work for the nuclear. So the second phase is where we are as a country, is the preparatory stage where we look at issues such as preparing the population to understand about nuclear, sensitizing stakeholders and the people, building the seed human capital that will work at the nuclear plant, thinking about how you're going to finance the project, thinking about this emergency planning, thinking about issues of radioactive waste, and so management, and so forth and so forth. And finally, it is the stage where now you go into the construction phase. Now, why did Kenya consider nuclear? It's based on the planning for the country. Under Vision 2030, there are quite a number of projects that were identified, and of course those projects had to be powered. And through the country's energy planning mechanism, which is known as the Least Cost Power Development Plan, nuclear has been considered to be onboarded as one of the country's energy sources by 2034. And as I mentioned, according to that milestone approach, there are many years have to go into the preparatory work. So we are at the stage where we are addressing the preparatory activities, and we hope to start construction of the first nuclear power plant in 2027. That is supposed to be preceded by a number of activities, such as the strategic environmental and social assessment exercise, which is a global kind of initiative where you look at the economic and social issues around nuclear. And we did this from the year 2018 and went around the country having conversations with Kenyans and asking for their views about the nuclear program. Then we are also required to develop an appropriate regulatory framework, which we already have in the nature of a national nuclear regulator. We have a national nuclear regulator, which I always say is the equivalent of NEMA, or I call it the NEMA of nuclear. So we have the Kenya National Nuclear Regulatory Authority that superintends all issues regarding nuclear in the country. After the CESA activity, there are also preliminary issues that are supposed to be undertaken, because after you identify the site that you want to locate the nuclear plant, then you have to undertake what is called detailed site characterization. Again, a very costly exercise that involves a lot of financing and studies that require to be undertaken. So in terms of the financing, as you mentioned, there are a lot of activities that cannot be taken by a financier. Most of the ones that I've talked about, they're upfront project activities that many financiers will not like to be engaged in. And this is where we start discussions about concessional funding that will come from sources that are going to offer friendly and affordable capital. In regards to our country, up to this stage, most of the funding has tended to come from the government. There has been no funding coming from development partners or otherwise. But as you are aware, with the other pressing demands that are put on the Treasury, there will be a need for the country to consider other sources that will support these activities. And we are then undertaking studies and discussions to see the models of funding and finance that we can look into. And some of them that we are looking at is to see how we can reach out some of the funds that have been discussed here. It may interest you to note that for a long time, global financial institutions, particularly the World Bank, have shied away from nuclear because of what you mentioned, because it has been controversial. But this is actually being changed, because in COP28 and COP29, the nations of the world have given a commitment to triple nuclear energy by 2050. We are talking about currently the world having about 415 nuclear reactors. We hope that this should increase to more than 12,000 by 2050 to be able to address the energy needs that are required. And this is particularly important for Africa because we are talking about a continent where more than 600 million people lack access to electricity, and more than double that do not have clean cooking fuel. And we see that with the trends that are growing, in regard to e-mobility and so forth, that nuclear will be an important source of electricity that will be able to provide baseload and guarantee energy security for our country. And it's also important to think about nuclear because when we're discussing climate change, the traditional sources that have been providing renewable energy such as hydro and wind and solar can be are being largely affected by climate change because we are seeing scenarios where some rivers are flooding drying up, and that source is affected, and so forth, so forth. So if we are thinking and planning appropriately for the country, we then need to think about this source. In regard to the financing, there has been a big problem in the sense that many a lot of private capital is not willing to come on board because of the risks that are involved. And therefore, there's really a need that governments and concessional lenders can come into the market to support that. And this can be done by encouraging private capital to come on board by creating a robust legal and regulatory framework and having a policy that will give confidence to private capital to come on board. And this is where the judiciary will be very relevant in the sense that the private people who are putting their money in the market are after getting profits, and they want predictability, and they want to know that the contracts that they're going to sign are going to be implemented, and therefore they'll be thinking about such things. So that is the way I see the role of the judiciary. Thank you.
Thank you very much. Okay, so there is hope. The nuclear plant will be, the construction will start in 2027. So soon, and very soon, we'll have nuclear power as part of our national grid, but it's still a long journey. The financing bit has to be sorted out, the environmental concerns. Yeah, but that notwithstanding, I think we should remain hopeful. We should remain hopeful. So now, net fund. Your mandate is to, and you'll correct me, mobilize resources to promote environmental conservation. And I believe climate action should be part of that, and research as well. So it's good to know from you, Hassan Sheikh, again, using the motif of my grandmother, not that she's ignorant, no. She must be the cleverest person in this world. She pushed my father to go to school. My grandfather was not concerned because she saw the importance of education. So my inquisitive grandmother would like to know, net fund. What are you doing? First, are you accessing climate finance? And if so, how are you using that finance in order to build resilience among our communities and also empower communities to get mobilized and participate in climate action? From my grandmother's perspective, would like to hear an answer from you. Thank you very much.
Thank you so much. And Net Fund, I think I will begin by saying you're right. The mandate of Net Fund is to mobilize resources, mobilize and avail resources for environmental management in the country. And so, but I must also say that Net Fund is a state corporation under the Ministry of Environment, Climate Change and Forestry. It's a government agency. And we receive climate financing, yes, because we are exchequer funded partly, but a substantial amount of our funding portfolio comes from our development partners. And yes, this goes to climate financing. In the recent past, let's say in the last 1 or 2 years, most of our programmings have been around what we call ecosystem restoration, because it is actually, it has become a pressing need and a huge challenge that our precious ecosystems, and mainly forest ecosystems, are getting depleted by the day. And therefore, responding to the devastating impacts of climate change require that we take care of our forest ecosystems and precious landscapes. This will, to a large extent, cushion us from the impact of climate change that we are talking about, because as you know, trees and forest act as carbon sinks, and therefore effectively responding to the emissions that actually cause global climate change. And so we have a number of huge programs that have been implemented or executed in a number of ecosystems. Kaptagat and forest, Penon and Sabot, not Sabot, Penon, Kaptagat, Penon, and a number of other forests around the area where we are right now. And ecosystems that we have been working on in the last 1 or 2 years. I will come to in much more detail what we are doing with the vulnerable communities inside there in a short while. But also Kakamega Forest, which is the only tropical rainforest in I think in the region, and it's also an ecosystem, a forest ecosystem that we have done substantial amount of work. And I will also, in a little while later, describe how we are working with supporting vulnerable communities. We have another program that, so we have been busy mobilizing resources for these ecosystems. So, whereas a lot of work goes to, hard stuff, restoration effort, fencing of degraded and threatened ecosystems, whereas much of the money will go to this. NetFund has ensured that of the resources that we are dispensing goes to enabling vulnerable communities that are living around the forest ecosystems and that have traditionally relied on the forest ecosystems for their livelihood, and are cushioned or enabled to respond cope with the devastating impact of climate change they are facing, because they are so both by enabling them to cope with this impact of climate change as secure action. I think basically we are talking about ensuring that communities, country moves to a sustainable development. So in all the forest ecosystems that I have talked about, and this is how your grandmother will do. The same way, the huge restoration efforts that I have talked about, restoration, when we say that, basically we are talking about planting of trees in the forests that have been degraded. So the restoration also, communities will partake in that particular activity, and they will be given employment, temporary employment in the process of planting and doing the afforestation. And apart from that, initially I talked about the fact that they will be trained on establishing tree seedlings. When they are trained and then provided with potting tubes and seedlings to now do the actual raising of tree seedlings, we then uptake those particular seedlings from the local communities, the vulnerable groups, which then will be used to do the afforestation in the forest. So it's a whole lot of holistic programming. And to us, I think that is a very good way of ensuring that the adaptive capacities of communities to respond to the devastation caused by climate change is properly responded to. And we will come to, you have said Masaku, yeah? Yeah. And we will come to that region. And of course, right now, we are responding to those gazetted ecosystems, main water towers that we feel really there is a huge impact coming from them, but we are going across the country. So when that time comes, I'm sure your grandmother will benefit. Thank you so much.
Thank you very much, Hassan, and good work you're doing. Protecting those protected ecosystems, I think that's very good, and providing communities with alternative livelihoods. Of course, after fencing off the forests, which is something that we also need to discuss, but not here, another forum. But as you also prepare your concluding remarks, it will be good to know how can NetFund work with the judiciary, and for that matter, the Environment and Land Court, in order to foster your mandate, but also to promote the role of judiciary in what you do within the context of climate change action. So it would be good to hear from you. Then lastly, last but not least, conflict, climate change. They say that climate change is now a driver of conflict in many parts of the world, including Kenya. In those marginal regions, it's getting much hotter, rain is no longer as reliable as it is. So there's a lot of stress on livelihoods of communities. So that has also predisposed them to conflict. In Samburu, there's been fights between grazers, conservancies of access to grazing resources, et cetera, et cetera. So we'd like to know from Dr. Ocharo, how can communities then leverage on peace messages in order to secure resources for climate change? And in all that, where do you see the judiciary also coming in order to support those vulnerable communities? Over to you.
Thank you so much. First of all, for the organizers of this climate change conference. It has come at the right time. I think it wouldn't have come earlier than this, just when the COP29 has been concluded. And also thanks to the committee for thinking about incorporating the issues of peace to these discussions. Whenever you discuss about climate financing and you leave the aspect of peace, then it means that it cannot be complete. There cannot be any project that will be implemented properly and become sustainable without the element of peace. And you have mentioned clearly about the issues of conflict. Whenever there is conflict, usually there are some root causes, and you have rightly put it that most of the vulnerable communities are the ones who continue suffering most, especially in conflict, because they are struggling for the diminishing resources they have. For example, if it is the grassland, you realize that most of the people there will be searching for this grassland for their animals. And because it is diminishing, violence will come in, and the strong person will win. So that place will continue becoming hostile and hostile because the communities are struggling for the diminished resources. There are also other places where climate change has caused the natural resources to diminish. A place where you cannot think of, for example, Kisii and Nyamira. Like people think that it's God's bathroom because it rains a lot there, it used to. But when you go to the rivers, there is no water literally because the eucalyptus, for example, that was planted earlier on is taking a lot of water and therefore the rivers are drying up. When you go to the spring areas, the trees that have been planted around there take a lot of water. By the way, if you didn't know, is that eucalyptus take about 20 gallons of water every day. So you can imagine if the spring is producing water for people and the eucalyptus is taking it away to the atmosphere, then this community is likely to suffer more and more. And you realize that now the communities around that area will not be sleeping. Women as early as 3 a.m., they will be going to look for the little water. So the place cannot be safe. The place cannot entertain investments because investors are fearing that this place is not safe, therefore our investments will not be safe. So they continue more and more to be vulnerable. So first, I want to highlight that peace is a foundation for collaboration. When you look around this hall, you realize that the Environment Land Court invited stakeholders from different places. We have, for example, the development partners. We have the local governments. We have the parliamentarians who were here yesterday. We have different arms of government. And at the same time, we have the international NGOs, we have the local NGOs, because we need to collaborate and attack this animal we call climate change to see how best we can be able to ensure that there is distributive and there is procedural justice. So I would say that whenever there is peace, then it is easy to have collaboration, because when we have conflicts, maybe violent or structural, there is no way collaboration can take place well, because every party is mistrusting the other. So this collaboration cannot work, and therefore the communities cannot think in terms of measures, be it mitigation or adaptation, that they can take up so that they can save the environment. The other thing I would say is that peace for resource mobilization. If there is peace, then it becomes easy to even convince the donors, to convince those ones who want to invest in our country to come and invest for us. I'm looking at the renewable energy investment. It's very costly. And there is no way you can convince the partners to come and invest when they are not sure of the security of their equipment. So I would say, first we have to ensure that there is a peaceful environment. For now, mobilize the resources well. Mr. Kotengo mentioned that Kenya was among the first countries to start receiving the climate fund because of the legal framework that had been put in place. And I want to also say that it's also because of the peace that we continue to enjoy. And you mentioned yesterday that most countries are coming in to find out really how Kenya managed to, get so much ahead of this. It is largely, it lies on the peace that is seen around. If there is political stability in the country, if there is a structural peace in terms of the institutions, where institutions are not struggling, where the independence of institutions is assured, then the resource mobilized will reach us well, and then the communities, even the vulnerable ones, will benefit a lot. The other aspect I want to look at is peace building for equitable distribution. And in peace building here, I want to look at the communities managing their own natural resources. So for example, our brother from NetFund mentioned that they are using the communities around the forest to manage the forest they have, yeah, because they're the ones who are there, and if they are involved in management, then you are sure that they are going to do it the right way because they are affected more. So we say that peace building efforts, when we have the communities, for example, managing the graceland, they are going to do it very well because they have been in those communities the longest. They know how they interact with one community and another, their neighbors, how they do it, and they usually have their traditional way of doing it. Maybe they could say that in this time of the year, maybe we should have this community grazing land more than the other one. I mean, there is a way that they do it very well. So that can help us in ensuring that there is equitable distribution of resources, because they are the people, again, who are going to be involved in designing the kind of projects, the initiatives they want to have in terms of the adaptation and mitigation. And lastly, what I want to say is that peace for community empowerment. We must empower our community. We must empower the women, because we are saying that women are the most vulnerable. Then we need to empower them so that they can take place, or rather they can sit at the decision tables and make that crucial decision. But if again there is no peace, these women will concentrate on other matters and will not even find a place to sit to make this decision. So peace is very, very important, and we are saying that it's not an aspirational ideal, but it's a fundamental prerequisite for fair and equitable distribution of resources. Thank you.
Thank you very much, Dr. Skeeter. I think an important message you pass across is that without peace, we cannot even dream of implementing any climate action. And therefore, for us to seek those resources, we need also to ensure that we have peaceful conditions in this country. So now, it's already, it's almost 11 o'clock, and we've run out of time. But I would like us to engage the panelists by asking them short questions, short, precise questions. We'll take maybe 2 here, 2 here, 2 that side. And then thereafter, we'll ask the panelists to wrap up. So, first come, we have 1. Number 2? Number 2? Or will you donate your slot to this side? No, number 2? Okay. Number 2 here. Okay, that's fine.
Thank you so much, panelists, for the wonderful insight and presentation. So my question goes to Professor Mbote. I don't know what strategies you can advise the nation to be able to bring home the principle of common but differentiated responsibility. Because we normally present that dialogue when it comes to global conversation, looking at the global north, south, the way they keep on saying they're also marginalized. So we want to see what really is the way forward for the Kenyan government, ourselves, to be able to implement that principle together in line with the recommendation that came yesterday in terms of just ensuring that the polluter pay principle is also given a lot of priority in our country in terms of also jurisprudence that we're getting from the ELC code. Thank you so much.
Okay.
Thank you. Mine goes to...
sorry, your name?
My name is Phyllis Chikemboi. Mine goes to Abuyabo, Senior Counsel. I like the idea of having the nuclear plant coming in 2027, but we know the issues going around. We know the issues of budgets. I don't know whether it will just be a story in this conference or indeed plans are underway, funds have been put aside. Do we already have investors for that project? Thank you.
All right, thank you very much. This side too, we already have two, yeah? Okay. Mhm. So panelists, please take note of the questions. You'll answer at the end of this, yeah?
Good morning. My name is Ryan Gitahi, and I have a question to Mr. Odengo. That framework of 1.5% and 50% and another 50%, can't it lead to marginalization such that if there are counties which are very proactive, they will get the money, but then those counties that are not proactive, they will not get the money, and their citizens will suffer? Because at the end of the day, even if we work through devolution at county level, we all pay our taxes to the national government in the end of the day.
And also, maybe in addition, if nobody works hard, where does that money go? Will it go back to the people who gave us that money? I think it was her.
Good morning. Thank you for the panelists. My question is to the gentleman
Your
from
name
Floka.
first?
My name is Esther Keike. I would want to know whether there is a real success story from the time Floka started, where you can tell us that you have given money and there is impact and there is adaptation, and like we said, our grandmothers can celebrate the impact. Thank you.
Okay, thank you very much. So we go to this side. I can see a couple of hands, so we'll take one and then two. Yeah, two. One, the gentleman behind there. Okay.
Thank you. My name is Nicholas Lagat. My question goes to Daktari from Floka. Daktari, is it not a plethora of committees and subcommittees formed in both the ward? Of course, I would want to speak on the case study of Uasin Gishu County, that ours ward project identification committees vis-a-vis the ward Floka committees. And at worst case scenarios, you would find that the members of these committees and subcommittees are the same individuals. Then again, if projects identified by ward project identification committees are the same projects funded by Floka, is that not double allocation or budgeted corruption? Because the money that is from the 40% ward fund would be missing because it would be funded by Floka instead of the ward fund. So then again, so how are we going to navigate around these committees? Thank you.
Thank you.
Thank you. My name is Collins Kimboy. My direct question is first about the mama, the shosho. The question is this Wanjiku anataka kujua atapataje carbon credit kwa M-Pesa yake in these 30 years. How reality is it? Because it has been a lot of we have a lot of theories in terms of having such kind of great engagement, high profile, but action is very less. The second question is about to nuclear Dr. Is it Ondeko?
Make it short. Everybody had one question to ask.
Sorry. It's just how, as a country, are we ready for that nuclear, and how prepared? Because we have a lot of great upgrade. Tuko na a lot of industrials ambazo zina grow. Tutakuwa tuna contribute to the gas emission again. Thank you.
All right. So I'll give judges 2 chances. Any judge who wants to ask a question? 1 second. Any? He's not a judge, is he? 2. Yeah, we have 2. Okay.
My name is Anthony, and mine is one question only. Yesterday, it is directed to you, Peter Oden. Yesterday, when you were talking, you talked of 3 factors. I think 3 requirements that are necessary for us to combat climate change effectively. One, I think, if I remember well, one was climate financing, the other one was capacity building, the other one was technology transfer. Now, when we went up to take tea yesterday, while talking with my colleagues, we realized maybe there could be a fourth factor. It's goodwill. Goodwill of all kinds, but let me not talk about goodwill of all kinds, but political goodwill particularly. And I'm saying this because we understand there is a powerful leader in the world who will be president next year who does not have the kind of feeling we have about climate change as we have right here now. Here in Kenya, we don't lack political goodwill. In fact, we enjoy quite a lot of it. But you tell me whether you agree that goodwill is necessary, is a factor, and more particularly, political goodwill, because I seem to perceive that it is that goodwill, if it exists, where all the other factors you mentioned can be actualized. That is my question.
Thank you. Then Justice Naikuni, your hand was up.
Thank you very much, moderator. Mine is a very quick follow-up to where Justice Kanyaru has left. And specifically, my question is directed to the two professors, Professor Kamone Mbote and Peter. It seems like you have put so much premium to access carbon credit financing onto our legal framework, the Climate Change Act. From the presentation by the Professor Kamote, is that starting from Paris, the Rio, there's a lot of international legal framework out there. But coming back home, honestly speaking, the climate change legislation, starting from the act itself, honestly, it's very, very skeletal. It cannot even accommodate some of the fantastic suggestions that FLOCA is flowing out here. So what is the starting point? Do we start by engaging our legal environmental, legal environment, which to me, it's honestly speaking, it's scanty. There is very little that we can, in comparison to what is there internationally. That's my, I don't know that I'm clear.
Right, thank you. Thank you, Justice Naikuni. I think your question is clear. So I will invite the presiding judge, Justice Angote, to join the panelists here. As the panelists respond, I also request them to say their last word, yeah? In relation to the questions they were responding to. Then finally, we'll have Justice Angote also give a perspective on the judiciary, and then we end this session. Now, unfortunately, for those who have questions, let me ask you to note them down, pass them forward. I'll see how best to distribute them to the panelists. The people with the mics, please help me get those questions from the participants. So we'll start with Prof. Mbote.
Thank you very much for the questions. I think one question that was directed at me was on this principle of common but differentiated responsibility. And for those of us who are in Rio in 1992, we know that that was one of the biggest wins for global climate multilateralism, because when you talk about giving resources, there is a unidirectional flow from the not very well-to-do to the very well-to-do to the not very well-to-do. And this principle is still contentious. At international spaces, you have very many member states not wanting to buy into the common but differentiated responsibility. But thankfully, we have big countries like Brazil, which really stand for this common but differentiated responsibility. And it may look like it is not achieving much, but I'd like us to look at the glass as half full, not half empty, because we already have a loss and damage fund that was agreed to in Sharm el-Sheikh, and that has been now actualized and is being given teeth. Then we also have the funding. The question of funding has refused to go away. I think Dr. Ombua talked about how by 2019 or 2020, when we expected to have $100 billion, we only had $89 billion. But now we have gotten to 100 and the ambition has gone up. So in essence, the multilateral space is accepting the common but differentiated responsibility. But I think it is important, you asked about strategies for Kenya. It's important to cascade this common but differentiated responsibility, which is a principle of equity, to lower levels. So when Kenya or any other member state negotiates for common but differentiated responsibility, they should cascade it down to people within the country. And that is where when people are talking about Wanjiku, or you're talking about Mama Mboga, I think it is moving from the state to the different active parts of the state. I think the other question by Justice Naikuni on having a very skeletal climate change law. I think we cannot have a climate law that is all-inclusive, because climate change is multidisciplinary. And like, for instance, now we're talking about finance, but we're talking about finances that will be applied to an environmental context. So you require some sophisticated understanding of the landscape of both climate change and also financing. But also to say that there keeps being concerted efforts to make the nationally determined contributions a lot more ambitious. Right now, we are going to the next iteration of the nationally determined contributions, and in Baku, the rallying call was, we want more ambition. We want more ambition, and more ambition means reaching more, having what was referred to as procedural and distributive justice. So I think substantively the rights are recognized, but we need procedural and distributive justice. And I'd be remiss, I think, if I didn't say, when we talk about intergenerational equity, we are always talking about we who are here and those who will come after us. But there is quite a lot of concerns now about the elderly and how the elderly are being addressed when it comes to climate change. And the European Court made a decision which had been brought by the elderly women of Switzerland against the government, that it was not taking enough measures to cushion the older people from climate change. And then my final take, climate change is a big problem. It takes all of us. I think from the discussions we've had, governments will not have enough resources. I think multilateral donors also don't have enough resources to give us to deal with this issue. And even the multilateral development banks don't have enough. So we need to bring everything together. And we see the emerging role of the private sector. And I think that is one area where we can actually harness resources to come to us. And of course, there are many issues about greenwashing, but those can be dealt with in legal frameworks. Thank you.
which are very good. I am inviting you. Yesterday there was a very good green prayer. I hope you've not forgotten the green prayer, the prayer of Garden of Eden. How soon do we forget? Look at that photo at the top of the flocker. If you listen to that prayer, that is what the Pope or Pastor was talking about. You look at it. You know, chances are very many, anybody can take a title, whether a Pope or a sheikh. But that, if you look at, take a moment and look at that thing, that photo. You see a river with the very clean, sparkling water there with some blues, a very good ecosystem, which means everything is in it. The peace that has been talked here, if you live there, are you not in peaceful environment, honorable judges? And when you look at the biodiversity of the surrounding, then if that is the prayer that we agree that was the best, okay, let me respond to my colleague. Question number one. One, fairness, equity, and all in one, and no one should be left behind. It's a very mathematical model that is designed to ensure that there is no marginalization. Because at the time of the design and even now, there is marginalization. So when you want to design a Mercedes-Benz which fits for purpose, you start from the problems that you have. 1.5% minimum of local allocation from your county is simply a commitment which is linked with what the Honorable Judge asked, political goodwill. How do you assess a political goodwill? A political goodwill comes in that a governor whom you appointed or you elected has a goodwill to allocate resources to you. So that is a goodwill, and 1.5% in that. So that means that there is a start, that this is a good program. Two, the FLOCA program, for example, I'll give you figures. People don't want to talk to figures. When the resources are coming, people talk very vaguely, resources. But nobody gives you a figure, and the figures are there. So if you don't know the figures, you will not be transparent. And if you look at the FLOCA systems of success, there is something called transparency. If my grandmother does not know how much FLOCA asks, she will not ask any question. So number one, first of all, from day one, everybody in the county knows what the average allocation is for them. It is $1.25 million. From day one, they know that FLOCA is allocating money for capacity building. It's called institutional support grant. It is not TA. The language of TA is very bad to my grandmother. By the way, we are not talking about Wanjiku and who again? We talked about Wanjiku and who? Mama, they have been disappointed, and if you go to them, they will not give you a second to talk to them. That's why we are talking my grandma. My grandmother will listen to us because there is hope. And yes, you have to. So the 50% is given to across the board. The competition is only about the balance. For example, currently, if we put the total amount of the FLOCA, the direct money in the kitty is about $300 million. Of the $300 million, every county, after having the readiness minimum, has got allocation of 11 million per year for 3 years. That one is given, totaling to 1.48 billion. That is going to all the counties. Very good. So that is known per year for 3 years. And this is supposed to strengthen their capacity. And that is linked with those multi-level committees that I will respond there. So that is not TA. Let nobody come with a TA to say to the office to tell you he's building your capacity. TA does not. FLOCA gives 2 grants for my grandmother to manage at that local level. What is that grant of $100,000 per year for 3 years? And now after getting into the main investment, now they are allowed to access up to 5% of the total amount of the investment that they get. So it means it is more. Then the 50% is competition. If you don't compete, you will never do business. Professor just talked about the private sector. Anybody who is sleeping and does not compete will not go to the next level. Innovation, transformativeness requires competition. Elon Musk is a very good competitor in the Silicon Valley. And you see where he's trying to go, and people are following. So we need to compete to get to the best state that we want. And that competition is where there is 50%, and of the 50%, like what we gave this year, is 7.38 billion, the money that the president promised during the Africa climate. We are the only people that fulfilled our promises. We delivered it to my grandmother now, so they have it. The counties have also delivered their 3 billion, 3.2 billion, at a minimum of 1 point. So we deliver on that. The aim is to achieve that top one. So please, no money goes back to anywhere. The money that we get, whether it is for concession, it is only for concessional loans and grants. It goes back nowhere. Climate change and environmental degradation and pollution knows no boundaries. If you are sleeping in your ward, we will add the next ward, which is active, more money to do more, so you can go and borrow water there. See, Africa, we borrow salt, and people will laugh at you that you are coming to borrow our water, yet because you could not access Floka money. You know, it is very embarrassing in the village. So please, money does go anywhere. In ward level, we can give any ward the whole Floka 30 billion, so long as you can care. Because when we are reporting as, we will be now reporting as a ward to the NDC 3+. We aggregate them. We first start reporting as a village. Your village has to report. Then we aggregate them to the ward, then to the county, then to the nation, then to the continent. So it starts at the ground level. So at the national level, whether your ward was sleeping, your next ward was, the neighboring ward was doing very well, we still have a landscape. That is why we call it climate finance landscape. Secondly, in Floka, there is no piloting. You don't pilot with climate change. If you pilot here, that there is not enough water for 3 years, and the neighboring village will miss water for the next 3 years, and then during that 3 years, the ground aquifer has got no more water because there is no recharge from the catchment area. So you have now disadvantaged the neighboring village. Are we getting the logics there? So it is everywhere. So the only thing that if you don't want to be with the rest, then you will sort out at that level. So there is no money going on anywhere. We are distributing the money to achieve the universal global 1.5 research. But that is at the local level. That is what common but differentiated. So that common but differentiated, we have already translated it at the village level, at the ward level. And the resources is available to make you do that. If you don't do it, I think, Honorable Jai, the best thing is to jail those guys. Yeah, you don't need evidence, because there is a very good precautionary principle say that this guy, there is Floka money here, which is allocated, and they have just refused to take it. That is an intention of doing a bad thing. What evidence do you still need before a court of law? And I have the data, and it has been announced, and it is the neighboring county knows they got it. So, is there a true story? I want to see the person who asked the question, please. The true story of Floka, where is the impact? I didn't see you. Now, yesterday, after talking here, I was not with you in the afternoon. I went to Trans-Nzoia, County Atawe, to wonder if Floka money is being used. By 5:30, I removed the people from the offices because my team are there. As we are sitting here, there is everywhere, all the Floka team are everywhere, Kilifi, Tanariba, and I get the data real time. But because I was here and I'm leaving here to go to this one here where you are, the county of champions, we want to know how they are supporting those champions. So, yeah, Floka supports everything for livelihood. So we got those guys from the county, and in the office, their words were not good because this is locally led. So I told them, take me, my minister want to come and see a successful Floka story because we gave you money. Tomorrow at 10. Just get me out, I don't want to be in this meeting, take me to a place. The best, because the minister is coming tomorrow. It was a little bit tough. So it was very tough. It was no notice. Nobody knows that I was going with my program. You know what happened? They delayed, but finally the press was told mother, then they told us to go. So when we left the office, county office, they started driving very funnily, as if, yeah, as if to say the time is running out, and then now, but finally we reached. It is my grandmother who was passing, who confirmed that indeed, this water point was drilled many years ago. It collapsed. The generator was not even working for many years. They were required to pay money, but they did not have it. It was in a school. But since it was done, we turned to a solar pumping, whatever, 3 months ago. They are now getting water. And the men who used to ask them, why are you leaving the house at 5:30 in the morning? Where are you going? Now are clean and doing whatever. So I offer you, it was very interesting. It is there. Then finally, no.
Before you
So-
go, finally, there's a question here. Maybe you could answer it as you wrap up. If ward committee is not receiving adequate support from the county government, particularly the Ministry of Environment in that particular county, what recourse does that committee have? Or do you want to say they should go to court?
No, they should not go to court. The Flocker PIU has got a very well-robust M&E team that has got an overall overseer on all these MDS because we finance them. The Ministry of Environment, we give almost 300 million per year. So if we finance you, you also have to listen to us. So they don't need to go to court.
Okay.
They simply need to come to us, and we'll pick it up with the headquarters. Like yesterday, there was an issue of NEMA licenses. I don't know, where is the NEMA guy? Because we also finance NEMA through Flocker to support the counties to fast-track the issuance and screening of those projects so that no NEMA project can have a maladaptation or negative impact on the local community. So NEMA must do that.
Okay. Now, to wrap up, we need to wrap up.
Plethora of committees. The more we have the committees, the better. Nobody should be left behind, and no one should pull people there. So the more the committee they have, because they have the same goal, resources are available, and because these committees are elected by the people, Flocker gives the people the power to do your thing and the money to budget and use. So we cannot deny them. And whatever comes in the PCRA, that's final. So if there is whatever, it is your responsibility. Go to that meeting and make them, because it is locally led. And nobody can change that, even the governor. We have projects which have been proposed. Yesterday there was Thunder, and I saw Thunder, there was a project in Busia, Thunder arrested, to arrest Thunder in Busia, under Vlog. Initially I was asking, what is the rationale of this in climate change? But now when I refresh to my climate science, the more, as the rain become more frequent, and the air pollution get increase in the atmosphere, the ions in the atmosphere during the rains become more and more frequent and intense. And because it has predicted that the globe is warming, then there is what we call climate change rationale with the communities to say that they need use Flocker money to install lightning or thunder arresters because it has been killing themselves, goats, and their livelihood system. So it was
Okay.
That is the innovation.
Okay, all right.
Sir, let me just finish. This is very good. I know. So, Judge, political goodwill is the most important thing in the National Treasury. We have it up to the presidency. That is why we have got this one. But I did not mention it because I was talking within the framework of Paris Agreement and UNFCCC. So political goodwill, number one. That is why the Chief Justice is your political goodwill. Because he was here, you have it. So you can move. No question must be asked.
Dr. Odhengo, I should have asked you to write down your responses. I read them.
Come on, credit, please follow me, and the rest one I will respond later. Thank you very much for that.
Thank you. All right, thank you. Thank you very much. Yeah. So, for for Buyabo and Hassan, as well as Dr. Skeeter, I'll request you if you can respond to the questions and wrap up in 3 minutes each so that we conclude with the judge.
Okay, thank you very much. I think the question was from Phyllis and the gentleman here about whether we have budget and whether we are actually going to deliver the project. What I'll say is that the challenge that has been around these projects that are very expensive is because capital in accessing capital in Africa is quite expensive because we actually access capital at 3 times the cost what the developed world does. But I think conversations have been going around around that issue, and discussions are advanced, and we hope that some changes are going to be realized because with the Global South ganging up together and making the point as they've made in COP29, I think that voice will be heard and will get money. But what I can say is that energy projects are very attractive to investors, and I'm sure many of you have seen how everyone is running for those because they always pay for themselves instantly, because once you switch on a nuclear a power plant, whether it's a nuclear or hydro, and you start selling electricity, you're going to get your money. It's not like projects such as roads, which you have to depend on taxpayers to pay for themselves. So they are very attractive, and we believe that with the way we've been following the milestone approach given by the IEA religiously, we should be on track to actually commence construction as planned. Thank you.
Thank you very much. Hassan?
Thank you so much. As my parting shot, what I would want to say is that when we're talking about climate change, response to climate change, I think adaptation is coming out as the main thing and the most rational thing to do. And when we're talking about adaptation, basically we're talking about building the capacity, the adaptive capacity of communities, because climate change does not only affect livelihoods, it affects lives as well. So enabling communities, vulnerable communities, to adapt to the realities of climate change, I think that is where the catch is. And we will be appealing to many partners to join us in the work that we are doing. And on this note, I really wanted to call upon the court, the ELC court, if they have not done so, to consider adopting forests or ecosystems where they can do afforestation and reforestation, but also working with communities around that and enabling them to adapt to the effect of climate change. Thank you so much.
Oh, brilliant. That's in line with green justice, or is it greening justice? Okay, very good.
Thank you so much. For me, what I would want to say is that conflict resolution, peace building should be closely knit in the tapestry of climate finance, climate action, and climate justice. Thank you.
Thank you very much. So for those who asked questions, I think they've been responded to regarding the committees, FLOCA committees, and how they can better engage their departments. There are questions on carbon credits. I understand there will be a panel in the afternoon that will be looking at carbon credits. So those of you who wish to get more information on carbon credits, please join us in the afternoon. FLOCA, I think Dr. Odhengo has explained a little bit more on what FLOCA is, and in very simple terms. So I think that has been responded to. So thank you very much, participants. Let me ask presiding judge, Justice Angote, to also give his parting shot in terms of what this means for the judiciary and particularly for the ELC.
Yeah, thank you very much. Let me take this opportunity to thank the panelists. If you look at the program, the theme of this panel was very critical, just like the rest of the panels, because we were looking at how do the vulnerable communities access information, access, how do they know that the monies that are being given to this country are used in a more accountable and transparent manner, and also to look at the issue of procedural and distributive justice around the question of financing. And when you talk about procedural and distributive justice, we are just saying, is everybody accessible, or can everybody access information in matters of financing? And we've actually received the information, a lot of it from Mr. Odhengo, but do people on the ground know about what he has just told us? Are they accessing what we call justice? And then thirdly, are they being involved in all those activities? And having said that, the question that is going to arise, and it has already arisen, is if the communities are not satisfied with how the finances are being utilized, what is the role of the judiciary in that kind of a dispute? And it becomes very important, and it's, in my view, part of the climate financing arrangement, that the judiciary should be involved in all these aspects, especially in matters to do with the capacity building, and also in matters to do with just knowing which frameworks have been put together, especially by the counties. And if you look at the dispute which is already in Homa Bay, it is exactly the issues that we are discussing. Are people getting the information that they are supposed to get? Are they participating? And are they getting value for the money that is being given to the country? And therefore, for the first time, the judiciary is now being involved. And I'm very happy that indeed FLOCA has started now realizing that the judiciary is part and parcel of the climate financing arrangements, and therefore they must involve it at every level. And there are two ways, in conclusion, there are two ways that the judiciary also needs to take responsibility so that it can show the commitment, is that we also need the kind of financing which we will put into place what we are calling green the judiciaries. So that we need to go solar. When you're talking about all the courtrooms, we need to go solar. We need to go digital completely. We need to do transcription. And therefore, in the process, we'll be telling the public that, yes, you are doing your bit, but also the judiciary is doing its bit through the support of these funds that actually exist. So let me finish by saying that we had a conversation with the PS Treasury, and we agreed that indeed we need to have a written arrangement so that we are in the mix of everything in terms of implementing these programs, not just FLOCA. There are other programs which Mr. Odhengo has not mentioned. There are other funds, and therefore want to know how are these other funds being utilized. And therefore, we are going to take this conversation further by getting into a written arrangement so that we are able to be part and parcel of the process. So once again, thank you very much to the panelists. We are so much empowered, and we look forward to the implementation of the things that we discussed. Thank you.
Over to the moderator, the chair of the session.
Was I the chair? Thank you very much. I think a hearty clap to all of us. Professor, always a pleasure and refreshing. Dr. Odhengo will continue with the conversation. I'm not so sure I've convinced everyone that our grandmothers, all of them across Kenya, understand this. So I think we have another side chat on carbon credits, an interesting conversation, because I think we are taking a long time to understand it, and yet others have moved ahead of us. So we don't want to lose. So let us get to the conversation. If you are here, thank you, Wabuyabo, for coming, Hassan for representing your boss, Skita, always good to bring in the issue of peace. You didn't talk so much about gender. I was expecting it to come up, but thank you for that. And of course, our principal judge. Thank you for nailing it down for us. And of course, our moderator, thank you. Come in handy to actually present our issues. By the way, Dr. Wambua Kituku has a doctorate in environmental law, has done a lot of work with the UN bodies on environment, but also on democratic governance. That's how we first met a few years ago. So thank you. Another clap as they take. their step down the stage. Asante. To the next session, we wanted to have 1.5 hours of our side meetings. I think we have 3 breakout sessions again. 1 here, 2 outside. There's, I think that's tent 2, and then 2, and then 3. I would like to ask that we have, and thank you all for coming. I think today we have all the panelists in-house. So for the breakout session number 4, I'm trying to rush, sorry. So I'm trying to breathe very hard. We have Honorable Justice Koros as the chair. Is she here? Yes, thank you very much. And of course, the moderator for the session is Justice Olola Otieno. Please come in front because we'll ask the panelists to follow you. In this session, we are discussing climate change and natural resource management. We have Engineer Ngeno. We have Honorable Justice Anna Omolo, sorry. We have Jacqueline Kimeo, representing Jackson Kiplagat. Then we have Ombua Kituku, who just left the stage. And then we have Jaswinda Bedi, thank you for coming. Soine Parsena was here with us yesterday from Semiride. You are in that panel. So you remain here in the dome tent. Our chair will be her, then we have our moderator. So you'll remain here. Thank you. We are consulting a bit. So we will remain here as the panel session 4. We have breakout session 5 in tent 2, discussing interlinkages between gender and climate justice, the challenges and way forward. Here we have Honorable Lady Justice Millicent Odenyi. We have David Obudo. We have Dr. Moses Maranga, Andrew Leting, and Phyllis Chepkemboy, and the moderator is Justice Stephen Kibuja. Kindly come up. Thank you very much. So all those who would like to go to session 5 will go to tent number 2, and we'll have our moderator to follow. Then we have breakout session number 6 in tent 3, which is over there. The theme, Artificial Intelligence and Application of Geographic Information Systems, that's GIS, in judicial decision making. Here we have Honorable Lady Justice Mbugua. We have Husna Barak, I'm told she's also around. Dr. Ruth Aura Odhiambo. Then we have Dr. Nabil Orina. Our moderator will be Brian Sengeli. Let's see you here so that we can follow you. So for that tent, that session will follow Brian Sengeli. So the request I've received is that we can have a 10-minute break, but as we finish, those who would like to come back here, let them come back here. Then we'll have those going to tent 2 and tent 3, we'll follow them. We have a few of our officers who will assist us to move to the tents, just to whip us slowly to those tents. Let's agree on the time. So 11:40, 11:50, we finish our break. Can we give ourselves 1 hour, 20 minutes for the session? Will that be enough? So what time do we get back here? 1:15. Yes? Can you say 1:15? We are back here for the recap session, kindly. So would that be okay? Yeah. Thank you. Let's take the break. And thank you very much for being patient with the morning session.
Hiyo ni mambo ya chair.
Like it. Good afternoon. Good afternoon, everyone. We want to call the session into order. Some of our panelists are present. Our moderator is present. Dr. Wambua Kituku, are you present with us? Dr. Wambua Kituku? Mrs. Soinei Parsenia, she's present. Engineer Festus Ngeno or his representative? Anybody representing Dr. Ngeno? Mr. Bedi is present, Justice Omolo is present. We will call the meeting into order, and once the other panelists come, then they shall be able to join the podium. Mr. Jackson Kiplagat, are you present? Mr. Jackson Kiplagat, or a representative of WWF? They do not seem to be present. There's a representative. So I'll call the session into order. The session chair, Justice Ann Koros, and the moderator is Justice James Olola. He'll be the one moderating the session. Today's session is about bringing various stakeholders on management of natural resources. And we've had the earlier panelists indicating of the various roles they play towards climate financing of our natural resources. So this particular session will look at management of natural resources using different ways by different stakeholders. Kenya is blessed with several resources such as minerals, water, renewable energy, wildlife, and land. And Article 69 of the Constitution places a responsibility not only on the state, but also every Kenyan, every citizen, and every entity on measures they must take towards protecting and conserving the environment. It also places a duty on citizens to cooperate with the state towards achieving this effort of management of natural resources that Kenya is blessed with. And the citizens or all persons can also participate in that by bringing legal action to ensure that the state carries out the mandate it has to do. So for this session, as I'd earlier mentioned, Justice Olola is going to be our moderator, and our panelists for today are Justice Ann Omolo. Justice Ann Omolo, if you're present, kindly join the podium. We have a representative who is representing WWF. I believe it's Jacqueline Kimeu. Kindly join the podium. We have Mr. Jaswinda Bedi, chairperson of KEPSA. Kindly join the podium. Mrs. Soinei Parsenia. Kindly join the podium. Mrs. Parsenia, you will indicate to us which entity you represent because it is not indicated. Dr. Wambua Kituku from University of Nairobi. I don't know if still there is anybody who is representing Dr. Ngeno. Thank you very much. Mrs. Parsenia is representing the Social Justice Activist Network, a network empowering Samburu transformation. It's an NGO called NEST. But in case of any clarification, maybe Mrs. Parsenia, you will indicate to us on that. Karibuni sana to the session. We are, the moderator is going to first ask the first round of questions. Thereafter, we'll have a response from the people present who would have a burning question. Then thereafter, we'll proceed with the second set of questions. Kindly allow me to hand over this to the moderator, Justice Olola. Karibu.
Thank you, Justice Ann Cross. My sister here is also the judge of my county, Siaya, so I have a lot of respect for her. As you've been told, my name is James Olola. I serve in Nyeri, Environment and Land Court. And this afternoon, I'm going to lead us in a discussion about climate change and natural resource management. We want to find out the role of our court in remedying climate change chaos. The presumption is already there's a lot of chaos in the sector of climate change, and we want to see what role our court can play. Sometime in 2015, about 196 countries met in Paris and in France, and they came up with the Paris Agreement. That agreement allows countries to trade in these things that we have been now calling carbon credits. As somebody said yesterday, some people who are polluting a lot are now being allowed to mitigate their circumstances by selling to those other countries what they are calling carbon credits, so that you can, as somebody said yesterday, go to Wajir and have all manner of acres of land, and then you plant trees, and then they say that now you can sell them some. If you sell like a certificate of carbon credits, like a metric ton of carbon dioxide or equivalent, and we want to find out from the panelists who are seated here. We have people from the government. We were hoping to have somebody from the Ministry of Environment, so the Department of Environment and Climate Change. It seems we do not have. We have people from the private sector, from the NGO world. We want to find out how we can collaborate in trying to deal with this area, this difficult issue of carbon trading. I will be asking them questions, and I think to start us off, now that there's no representative from the Department of Environment and Climate Change, I'll probably start with the Honorable Justice Ann Omolo. We are dealing with, the topic here is about remedying climate change chaos. And I'm just trying to look at us as a court, the Environment and Land Court. And I want to find out from her, how has this court handled cases on compensation of carbon credits? Have we dealt with such cases? And if so, how have we dealt with them? How do we establish that somebody, there might be a claim that somebody is saying that the project, the carbon project that I'm having, will bring so much value. I'm told it's called greenwashing. This will bring so much value in terms of carbon credits, etc. How do we establish that? How have the courts leveraged on that area of compensation of carbon credits as we go on. Thank you. You can start by telling us maybe the role of this court, the jurisdiction that we have, and how we deal with those environmental issues.
Thank you, moderator. The Environment and Land Court has played a role in protecting the environment, as the discussion has been going from the different presenters that have been before us. For carbon credits, we've not had cases because it's a new thing. But in terms of compensation for the environment, of course, the courts generally have played a role because we've had cases of pollution that have been taken up. Land use, which generally also relates to the issue of carbon credits. One of the presenters yesterday said that the people who are trading carbon make the owners, the community land, to be leased for a period of 30 years. And some of these, the challenges that would come before us would include land use rights, for instance, when they are when they're entering into these agreements, would they be having informed decision making? Would it be free will, or it's manipulated? And in terms of interference with the land use rights, how it would affect them in the long run. So the cases that would come before us would be land use rights, interference with the land use rights, that you would not be able to use your land for 30 years. So the money that you are being paid for the compensation, is it equivalent for the not using your land for 30 years? And also in terms of, they were talking about projects that are being set up. That means that there is no individual benefit. The carbon credit traders come up with things like maybe building a school, a hospital, and yet you are barred from using this land. So those are some of the cases that we are likely to receive. Secondly, in terms of assessing compensation, when you give up your land, like damages, the general damages that you'd estimate, probably if you are cultivating this land for maize, how much you'd get in a year, and for the number of years, or if it was for grazing, how much you'd be able to generate. I know there's a possibility that when you engage with the experts, that assessment of damages will be able to, the courts will be able to assess damages that will be payable to the owners of the land. But the greatest challenge as at now is when the decisions that are being made, when the contracts are being entered, are we able to, are the community able to make informed choices when they are signing those contracts? That means that even the possibility of the contracts being challenged would likely be brought before us. In terms of regulations or the law that is in place that will enable the court to carry out its mandate, under Article 2 of the Constitution, Kenya has adopted international agreements as part of our laws, the ones that they have signed. So that means that since we are signatories to the Paris Agreement, which basically regulates the issue of carbon trade, we are already in a better place in terms of what is the framework that is in place for use. Number two, the Climate Change Act is also in place to guide us. And in June of this year, we had the carbon credits regulation that was gazetted, that also will be, the court will be using as a reference when they are handling cases that will be coming before us. So as at now, we have a case that is ongoing, which is not included, but it's not carbon credit. It's in terms of the effects of climate change on the community around where the case is ongoing. Thank you.
Thank you, Judge. Thank you for that great response. From that, we hear that Kenya, we still do not have cases about carbon credits. And that is probably because the Climate Change Act was amended just last year, in 2023. And we are happy to hear that they are now, the regulations are now in place. I am sure that Judge Omolo, when those matters come to you, you will be able to calculate damages in terms of compensation. Judge has already done a great job in Mombasa, where she dealt with the Owino Uhuru case, where I think she developed great jurisprudence in terms of awarding rewarding those who have their environment polluted by others. Thank you very much for that response. I will probably proceed to Ms. Jacqueline Kimeu from the Worldwide Fund for Nature. That's a non-governmental organization, and we want to just hear from them. They have been in this country from the 1960s, trying to help communities deal with sustainable natural resource management. And what we want to hear from her is that is a question, considering the trends in climate justice, how can non-state actors like WWF collaborate with this court in addressing the challenges arising in climate change and natural resource management, particularly in the rising carbon markets context? Please, Ms. Kimeu. Thank you.
Yeah, thank you very much for that question, and also to add to what has been mentioned. The carbon regulations are here with us, and first and foremost is to applaud the government in this taking the bold step in terms of coming up with the carbon regulations. WWF have been part of the stakeholders that have also been contributing to the development of the regulations. And this presents a great opportunity for the Environment and Land Court, first and foremost to ensure that carbon markets and whatever we are doing is adhering to the principles that have been set in the regulations. First and foremost, the first principle that has been set is are the carbon markets really contributing to emission reduction, because that is the basis of it all, and also does it contribute to the removal of greenhouse gases. Then secondly, is this really contributing to environmental, or rather adhering to environmental integrity? Some of the key principles that the regulations really have put forward are very critical for the Land and Environment Court to really look into. So based on our experiences, WWF, we see a lot of opportunities for non-state actors, WWF, other partners, the media, even the private sector who are also non-state actors, and also, the local communities as non-state actors to play a very critical role in this regulation process. First and foremost, it's about, I will not talk about the free, prior informed consent by the communities. Our role as non-state actors is to really prepare these communities about the regulations. What does it say? And even for WWF, our role is to really support these communities to understand, now that the regulations are here, how can we make sure that they have the capacity to really translate these regulations into what they would, what it means to them. Then second is about benefit sharing, which is very critical, and the regulations are very clear. For example, you look at the regulations, it states that 40% contribution should go to the community in case of a public land. We envision a lot of challenges in terms of really implementing this, and the role of court will come in handy in terms of ensuring does the communities or the benefit sharing mechanisms that have been set by the regulations really been adhered to. And stakeholders also are coming in to really enlighten the communities about the benefit sharing mechanism. I want to talk about electrical wind power, which was alluded to yesterday. We see that this project is one of the highlights, and we see from the records that we read, it was supposed to contribute close to 700,000 tons of CO2 by the year 2020. But even up to now, there has been a lot of tussles between the community, between the developer and also the others. These are some of the things that with the regulations, we see that this will not be continuing. And with the court, I can say that you are really prepared to handle the cases, because they are likely to come in handy in terms of really benefit sharing mechanisms, and looking at that community where the wind power is, and the gains that such a private developer is gaining from such a project. 2 weeks ago we were there, and the community is living in darkness. They do not have power. Yet, this wind power is one of the largest wind power in Africa, and also supplies close to 17% of Kenya's power comes from that community. And the community is in darkness. They are lighting, the really traditional mode of lighting systems. So we are talking about carbon markets is in the context of transition. There is no transition without communities, and the court should really look into these issues of benefit sharing and also really the principles of transition, energy transition in context of natural resources should really be looked at, because there are several cases like that where it does not adhere to the principles of that. Then also the regulation talks about community agreements, especially around the conservancies and also other communities. So development of these community agreements for carbon markets will also be another key aspect that we are looking into. Really, what does that entail? And for shared resources, the regulation is very clear that how the community agreement should really be developed. There is likely to be issues around community agreements that have been proposed in the regulations, and as non-state actors, our role has always been to really again enlighten how do you develop the community agreements for shared resources in different counties. And this will also be a very critical element that the Land and Environment Court should be prepared to also address in the context of carbon markets. Then also, previously, the carbon markets have been, the credits have been sold without environmental impact assessment and environmental audits. Like, we know of cases where before the regulations, some partners have already bought credits, and now the regulation has come in to say we need to have environmental audits in place, environmental impact assessment in place. That already is an issue, because some people have already sold their credits, others cannot get the payment because of that. So this is also another key issue around environmental impact assessment and audits for carbon projects that were already existing, and also within, given the aspects that play around carbon markets. That issue is very critical and is likely to come to the Land and Environment Court. And then lastly, we are looking at carbon registries. Our regulations talks about having a clear registry of carbon. How do we ensure that whatever is put in that registry is really what it is, or rather it is clear, or it is what is happening on the ground? So our role as non-state actors also comes in to ensure that the carbon registry that the country is going to develop must be very transparent, must be guided by the truth. This is what it is, because we don't want a situation whereby the carbon registry is there, some projects are not very verified and stuff like that. And then finally, it's about independent auditors for carbon, another aspect that we need to talk about, and also how do we partner with research institutions and also other learning institutions to really facilitate capacity strengthening of independent auditors of carbon markets. We know that of carbon credits, because currently we are very limited of those, and also our role, and as WWF, we have been working with the Land and Environment Court to really capacity strengthen on environmental issues, and also now we are looking at continuing the partnership with the court to strengthen the capacity of the judges around carbon markets, because this is a new issue and they also need to to be in cognizant on it. Then finally, again, it's about the role of media. What has been mentioned, like there is no compensation or cases around carbon markets that are being brought to the court. But now moving forward, we'll see a lot of those. So what we call upon, the court and other stakeholders is, let's partner with non-state actors to highlight examples of how compensation has happened for carbon markets, like, different cases. We need to really create awareness, highlight how compensation is happening for carbon markets, so that we can be able to learn, other communities can be able to learn from that. So I see a lot of opportunities around non-state actors working closely with the Land and Environment Court to really bring these issues out in the public. Yeah, thank you.
Thank you, Ms. Kimeu. That's a very elaborate response. Actually, that is all the issues you are raising are matters of concern. I was just thinking about Dr. Odhengo's grandmother in Wajir that he was talking about yesterday. Climate change issues are very new to us, and certainly judges require a lot of capacity building. But you can imagine now the ordinary person in the village, what is their understanding? And I think the second question I will be asking you is, what is the role of third parties? How do we even determine that when these people say they are reducing emissions of carbon, that is actually happening? And that is tied to my next question, because I'm going to Mr. Jaswinda Bedi. Mr. Jaswinda Bedi is the chair of the Kenya Private Sector Alliance. The ultimate role of trying to achieve is to try and become climate neutral, to try and achieve net zero, what they call net zero emissions, to achieve a balance between the carbon dioxide that is produced and that which is removed from our environment. And the Kenya Private Sector Alliance, they know how much emissions they do, but what we want to ask them is, what tools do you use as the private sector to measure carbon credits in Kenya? And how is the pricing for these credits? How do you determine the price for the credit? And what are the tools that you are using? So that we can see if what Ms. Kimeu is saying is real, that sometimes you may be telling us this, and in the register you are recording this, yet it is not the correct situation. Karibu, Mr. Bedi.
Thank you very much for that question, and I'm very happy to be here this morning. I actually thought this conference is just too important for us to ignore as a private sector. And as the chair of the Kenya Private Sector Alliance, I thought it's important that I come here myself and actually contribute to the little that we can, because we all know in the last 24 months as country Kenya, we have experienced floods. At the same time, we've also experienced drought, as you know, in 2022. So the world has changed, and the world is changing. What happened in COP29 last week, and the resolutions with the global north and south at 2 different pages, we all know that this is too important a subject that we should not, we should actually get into and sensitize and educate our society at large. And going back to your question, which is a very pertinent question, is what tools does the private sector use to measure carbon credits in Kenya, and how is the pricing for these credits determined? So basically in Kenya, the private sector uses a range of tools to measure and track carbon credits, with a particular focus on the development of a robust carbon market, which at the moment we don't have. So we're actually looking at how do we create a robust carbon market. The tools that we are using at the moment are 4 different tools. One, the carbon footprint calculator. This is where companies utilize calculators to assess greenhouse gas emissions from activities such as energy consumption, transportation, and waste management. This helps to determine the amount of carbon to offset through carbon credits. So that's the first tool that we use. The second one is carbon auditing and verification. Independent verification bodies conduct audits to measure actual reduction in greenhouse gas emissions. Standards like verified carbon standard or the gold standard ensure that the carbon credits are legitimate and verifiable, maintaining market credibility. And that is, I think earlier on this morning we talked about greenwashing and all that, and there's a lot of that happening in the world. And I don't think as a country, Kenya, that we want to be branded a country that is greenwashing. And so that verification is super important. Third is, of course, the carbon offset projects. This is where businesses invest in projects such as reforestation, renewable energy, and sustainable agriculture to generate carbon credits. This you've seen a lot in Kenyan private sector, where you've seen a lot of industry moving towards solar, renewable energy. The industry is moving towards that for two reasons. One is, of course, the climate agenda, which is super important. But secondly, it's also, I would say, in a way, it's like a forced diversion into that direction purely because of the cost of power. The cost of power is so high that it makes you uncompetitive. So that when you look at lesser of the two evils, it's let me go that route, and it will also help us actually help the carbon agenda. But you see, it's a double-edged sword, because if if energy costs were very low in Kenya, maybe we wouldn't be embracing this direction. And you'll see other countries where, countries where are largely dependent on coal fire, like South Africa and all, they don't want to participate in these discussions. And also the countries that have got heavy fossil fuels in their grounds. So I think we are blessed in a way that since we didn't have, we have no option but to embrace. And of course the fourth one is the technology and software platforms. Now this is where advanced software tools help companies track emissions and offset activities in real time, ensuring progress towards decarbonization targets and compliance with carbon credit purchase requirements. So this is ongoing, and with our technology-savvy youth, and we see a lot of this happening right now. People are even creating platforms, apps, to actually start measuring, because if you can't measure, I don't think you can justify what you're doing. The second part was the pricing of carbon credits. That was the second question that you had asked. And how this, of course, is just not a straightforward answer. It is influenced by several factors. Factor number one is the market demand and supply. The price is largely driven by supply-demand dynamics, and which is normally the case in everything we do, in commodities. It's all about supply and demand. As more and more companies commit to net zero emissions, the demand for carbon credits will increase. And once that carbon credit demand increases, we'll start seeing rising prices. Also, it depends on the type of project. The cost of the carbon credits can vary based on project generating the credits. For example, reforestation projects may cost differently than renewable energy or methane capture projects. So depending on impact scale and implementation cost, the type of project is super important, because that will determine the price. Three is, of course, the certification and verification cost, which I said, it's very important that the carbon credits that are verified by third parties, it was earlier talked about, often carry a premium to the assurance of the authenticity. So the authenticity is super, super important. And that's where that discussion of greenwashing is also important, that we should stay totally aware, because I know of other countries who are actually rushing into this direction without putting the structures, the checks and balances to ensure that there's no greenwashing. And then lastly, it's the regional and international policies that would be helping in determining price. So government regulations are super important, and that's what I think we're discussing today, legislation towards regulations, such as carbon taxes or emissions in the trading systems will also affect the price, as companies must comply with stricter standards. I don't know if you guys are aware, but starting 2025, which is in the next 6 weeks, the European Union is actually going to start putting a carbon tax on all imports. And a carbon tax will be determined on different product lines and a different percentage. So basically, I think Europe is taking a lead on this whole decarbonization, net zero emission agenda. And so the further the product, with the carbon footprint of that product entering into the European Union, will have a higher percentage. The exact numbers are not known at this point in time, but definitely they have a new climate regulation, and they have a new carbon tax that is going to be put on imports, which will probably also help their domestic manufacturing, because that becomes a protection mechanism as the carbon footprint of that product is reduced. I just want to pause there. Thank you very much.
Thank you, Mr. Bedi. When I was in private practice, I did practice a bit in Nakuru, and the name Bedi is a renowned name in that town. I was asking Mr. Jaswinda Bedi here whether he's associated with that name, and he confirmed to me that his grandfather came to this country in 1932. So they have been the business, textile business in this country for quite some time. Maybe the second question, I'm happy about what you're telling us is that I think we need to be very careful in trying to trade what we have now, because market perceptions will effectively eventually determine how much you can sell for and how much you can get for whatever you're selling. That means that those who are in a rush now that the regulations are just coming into place, you may end up getting very little value for what you have, and the best thing is probably to take your time. I wanted to ask, maybe the second question I'll be asking you after a while is this issue of greenwashing. We know this country for what it is, and looking forward, how is KEPSA prepared as an association? You will answer that after I've asked the other question. To think of how are you prepared to enforce compliance? Because the thing is, you can get into these greenhouse gas emission agreements either voluntarily or through compelled by regulation. How is your association prepared to ensure that the private sector will adhere to all these things? And my next question for now goes to Dr. Wambua Kituku. Dr. Wambua, we have been told there are very little cases so far in court about carbon trading and carbon markets and all these things. But looking at it from an academic point of view, what are the kind of orders that you think, what kind of cases do you think are going to emerge in the future? And what kind of orders do you think this could be giving in terms of carbon markets and what has happened in other jurisdictions? Thank you.
Thank you very much, Justice Otieno. So, on the first issue of reporting of cases, I think Justice Omola has raised an important issue here. How our reporting bodies treated the carbon or climate change litigation cases. By the way, carbon disputes will fall under the umbrella of climate litigation, and generally climate litigation has been defined as a case where an issue of climate change, mitigation or adaptation or climate science is a material issue for determination by an adjudicating body, either a court of law or a tribunal vested with judicial powers. Now, unfortunately, we've not been tracking climate litigation cases carefully as Kenyans, as Africans. Instead, we've relied on institutions in the global north. Like, for instance, the most renowned one is called Sabin Law Center. It's based at University of Columbia, and it partners with the London School of Economics. They've been tracking globally cases. So as at now, they'll tell you there are over 2,000 climate litigation cases before courts globally. But a big chunk of those cases are in the US, followed by Europe and Australia. Africa contributes about 9%. So Kenya has been identified by that case, by that center, as one of the 5 African countries with climate litigation cases before courts or tribunals. And when you get into their database, you'll find they've listed five cases. Now, I took time to look at those 5 cases. I could only identify 2. The Save Lamu case, which was a decision of the National Environmental Tribunal, and the Litain case, at least the preliminary orders from the court, yeah? But the case is ongoing. But then the other cases that are going on, or cases that have been determined, like the composition of the Climate Change Council, 2 cases actually were filed and determined. There's a case in Homa Bay on composition of the FLOCA committees there. So actually, we could be having more cases than those reported by Sabine Center. And the reason for that is sometimes these institutions have a bias. It's now referred to as global north bias. They'll only report what they think is important to them. So the challenge for us, and the challenge we need to throw to National Law Reporting Council is, can they also help us in reporting, especially on climate change cases? Because there's an anticipation that these cases will increase. Now for carbon cases, again, I looked into the Kenya Law database, and I saw two that approximate to a carbon dispute case. One was is a Taita Taveta case. It's a group ranch company, I think it's called Kagamba. Yeah? They sought to evict squatters from their land. And the reason they gave, among other reasons, is that they would like to put up a carbon credit project. So that was one of the motivations for kicking people out. I won't get into the decision. You can always check out that case. It was determined by, I think, Justice Kibunja. Yeah? So that approximates. It may not be your classical carbon case, but it approximates because one of the motivations for the plaintiff was they want to establish a carbon credit project. And the eviction of people, dispossession of people from their traditional lands is one of the main grievances directed towards carbon projects. The second case is a project proponent who wanted to put up a wind power project in Marsabit. And again, one of the motivations the proponent gave was that they were hoping to make some money from carbon trading from that project. So they were denied letters by Kenya Power, power purchase agreement, a letter of commitment from Ministry of Energy. So they went to court and successfully got orders of mandamus compelling those institutions to facilitate that particular investment. So those are the two cases that probably come close to this. But as Justice Omolo said here, I think there is a problem with the reporting of these cases, and that's something that Kenya Law Reporting Council needs to help us in. Now, what kind of disputes can we anticipate? I think Justice Omolo has raised quite a number of scenarios relating to the contracts around the carbon and the enforcement of those contracts, cases of pollution that may arise, issues of land use and compensation. So that's one broad area. Of course, our sister Kimeo here has also raised other issues on benefit sharing, participation of communities, etc., etc. But I would like to highlight just a few other areas where I see litigation coming up. One is on human rights and sustainable development, because our Climate Change Act imposes an obligation for carbon project proponents to observe those two important principles. Sustainable development, which is of course anchored under Article 10 of the Constitution, so it's a mandatory principle that has to be observed. So if a project does not promote sustainable development, I think anybody can challenge that particular project before the ELC. And the ELC has a mandate to interpret sustainability criteria in projects. So that's one area. And there are quite a couple of projects that are being fronted which may actually undermine sustainability. For instance, the green hydrogen projects, where people harvest hydrogen from fresh water using electricity. So I don't know how such a project is likely to leave African countries because we also need that fresh water for drinking and for other basic purposes. So why should we use our own scarce water resources to generate hydrogen that's going to be used in Europe is that sustainable? So I expect people to challenge those kind of projects if they are brought here as carbon credit projects. Second issue is human rights. Of course, you've had issues of dispossession, etc., etc. And thankfully, our court is vested with the mandate to also enforce carbon rights, but importantly, the right to clean and healthy environment, and the responsibilities of the state in ensuring that. So there is mandate there. Second area of contestation is on regulation. I think Mr. Jaswinta here has talked about regulation as an important factor in stabilizing prices. So the question is, so who has the mandate to regulate carbon credits, carbon pricing, the carbon market? Is it the national government? Is it county? The projects that give rise to carbon credits, most of them fall under the jurisdiction of counties: agriculture, water, waste management, forestry, yeah? So then, why should national government then purport to have the exclusive mandate to regulate carbon credits and carbon pricing? Yet again, if you look at the architecture of the Climate Change Act, climate change actions are actually, that's a shared responsibility. Even the Climate Change Council has both national as well as county governments represented there. So why then make the regulation of carbon credits an exclusive function? So that's an area there where some litigation is anticipated. And then on approvals, carbon credits are the projects are being implemented by private sector, where Jacinta comes from. And our private sector likes maximizing on profits. And sometimes they look at regulations as inconvenient obstacles towards maximizing on profits. So many times we've seen private sector going around regulations, ignoring EIA or conducting EIA in a manner that's not consistent with the law. And that has sparked a lot of litigation. So I don't see anything different from carbon projects. So that's an area, thankfully, our ELC has generated substantial jurisprudence on how to deal with issues around EIA disputes or ESIA disputes. The other area, of course, is the need for strategic environmental assessments. I think the Save Lamu case put an obligation on the state to ensure that strategic environmental assessments are conducted for large-scale programs that are likely to have impact across time and scales. So in our case, we'd expect certain carbon projects, like the ones involving Kenya and another country. They're called ITMOS, Internationally Transferable Mitigation Outcomes. It's under Article 6 of the Paris Agreement. So we would expect, if our government does not initiate strategic environmental assessments for that kind of projects, then there will be issues. So, but then, is it all rosy for ELC in determining these disputes? There could be some minefields ahead. The issue of jurisdiction. Remember the recent case, Bank of Africa versus TSS Investments, where the Court of Appeal said if a matter looks like the dominant issue is commercial in nature, then the ELC has no jurisdiction, notwithstanding that there could be issues relating to environment and land in that particular case. So if, again, these carbon credits and the projects and the disputations around are framed as commercial disputes, then there could be an issue there. But then, personally, my take on that is, for the ELC, please assume jurisdiction. Please do. For the reason that if you cede jurisdiction on one issue, you're going to open floodgates, and there will be no end to it. So let people go to Court of Appeal, Supreme Court, and let me also urge ourselves, scholars, civil society, when issues of jurisdiction of ELC come up in courts, let's also get in there as amicus and let's put up a good case for ELC. Because again, I've also looked at the cases where jurisdiction of ELC is under threat. Usually the person challenging the jurisdiction, there's a high subject matter value that is at stake. For the TSS, the banking business, it's a multi-billion, you'd say dollar industry in Kenya. So charging properties, realizing the securities that have been charged, that's a lot of money. So there must be an interest, therefore, by economic interest to whittle down the jurisdiction of ELC. Because again, as I said, sometimes protection of environment, satisfaction of land rights becomes an inconvenient barrier to actualization of profits. So I think those are the arguments we also need to start presenting to courts whenever the jurisdiction of ELC is challenged. The last point, again, on issues, the Climate Change Act and the carbon markets regulations insist on use of ADR in the community development agreements that will facilitate benefit sharing, as Timeo said. But they also emphasize that before parties go to court, they should also attempt ADR. So there is a possibility, and this also follows a global trend, that some disputes may be settled even way before the court is asked to intervene. Private companies don't want their credentials soiled in courts through litigation, so they will opt for ADR and things like that to resolve some of these cases. But then, is our ADR ecosystem in Kenya ready to take up on some of those disputes and resolve them in a manner that is also consistent with our constitution, that also puts our national interest at heart? So there could be a genuine case there for building capacities within the ADR ecosystem. Chartered Institute of Arbitrators, I think they need to be engaged, but also the alternative justice systems mechanisms that are likely to be employed in the resolving disputes for the community development agreements. Probably we also need to engage them a little bit more on why resolving carbon disputes in a manner that supports Bill of Rights, sustainable development, and our national interest as loosely defined, why that is important. And I wish to stop there. Thank you.
Thank you, Dr. Wambua. That's very informative. I think that is what people in my village call an expose. You can call it what you want in your language, but that's what they call it in Jajo Kongo's village. I think we benefit a lot from that. What I can say, the Court of Appeal are our superiors, and we have to listen to them. As a court, I can say that we have a stance. We always tell them that, and for now we can say that under the Climate Change Act as amended last year, the court there refers to the ELC. That is the same thing. I mean, when they talk about charges in, I think, Joseph Kang'ethe and Cooperative Bank, and they say that it's a commercial dispute, a charge is defined nowhere else in law but under the Land Act Section 2. And that act says the court is which one? The ELC. So there's a lot that we can rely on. As we move on, I just wanted you to start thinking about this, maybe to tell us legitimate expectations. Save Lamu was about coal power mining. The people of Lamu have this expectation that now they have landed on a gold mine. And then somebody goes to court, Save Lamu goes to court and says, no, we cannot have coal power here because it will be a pollutant to the archipelago that Lamu is and all that. How do you deal with those kind of expectations? how in future, how should this community be compensated for their legitimate expectation? Because they think they have landed a minefield, and then all of a sudden you're taking it away from them. So I just want you to keep that in mind as we move on. For now, I think I'll move to Ms. Soine Pasene. Is that how the name is pronounced? I hope so. Ms. Pasene comes from an area, I think, that is largely pastoralist, and with indigenous persons characterized by what we can call largely a patriarchal and socio-political setups. We want to find out from you, Ms. Soine, how have the conservancies engaged with the communities while negotiating about carbon credits? As we are talking about, building on what Ms. Kimeu had said, about the knowledge that these communities have about these things. How have they engaged? How do you engage with these communities while negotiating about carbon credit? And is there anything that you can show us that can demonstrate how these communities have benefited from those carbon trading agreements? How have they benefited? Thank you.
Okay, so my name is Soine Parseina. I know Parseina can be a Greek name. Yeah, so I'm representing Semiride, which also works with minority communities. And on the issues of conservancies, we need first to know who are these people who are around the conservancies. These are indigenous people. These are pastoralists. These are people, I feel like they're always left out. By the time the project is coming on the ground, it has already been decided somewhere, and they'll be the last people to know what is happening in the conservancies. I want to break that question into two. First, talking about the communities which are surrounding the conservancies. This is a new thing. Carbon market and credits is a new thing to them. Of course, there are private organizations who have already started doing the developments around there and crediting their lands without even involving the community. Conservancy are there, but the brokers are in between the conservancy and the community. And most pastoralists and indigenous people, they have community land, which has to go through adjudication and all that for them now to get their rights to the land or even get the title deeds. But who is going to explain to these people? Because yes, they have benefited. There have been projects have been done, primary schools have been done, boreholes have been done. Let's say like Kipia, Isiolo, and Samburu. These are the biggest people who have right now benefited to their carbon credits. But you go to the community, they don't really understand what is going on. They just know it is a project that is coming, conservancies are signing agreements, and all that. Yes, they are feeling the impact, but through projects. They are not benefiting directly from the investors and all that. Even in Kajiado, there has been projects going on, but mostly on soil issues. It has affected Olulunga, is it called Olarashi Ranch in Kajiado South. Orgululu Yorarashi Lands, they have done many projects, but to find even in public participation, indigenous people still don't understand. Because even as learned people, there are things we are learning from this forum right now about carbon credits. We are not even understanding where the nation is going towards. What is this? Even when you explain to someone, they think that you are taking their land. But literally it's not about taking their land. It's about you using that land so that we can reduce global warming. But if a learned person like me is even taking time to learn about it, what about the community person down there who is surrounded by that conservancy? Because many people who are benefiting from these carbon credits live in towns. What happened to rural people who are surrounded by all these projects? What will happen to them? You find that these conservancies are signing agreements without even involving the community. And what Semiride has been doing, they have been doing capacity building to these communities, trying to make them understand what are their rights on land and all that. You find that we have signed many bilateral agreements, let's say to UNDROP. Kenya is part of it, and it talks about the life of peasants. It talks about the people in rural areas. Is the government featuring them in the economical perspective of it? Yes, they contribute to all that money that the government is getting, but are they really getting the economic impact of all those things that we are signing as a nation? So for me, I feel like conservancies have a lot to do. The court has a lot to do, because the indigenous people have always had problems over and over again about land issues. And now this is a new thing about carbon credits. We already have issues about the forest being fenced, pastoralists being removed from their lands, so that trees can be planted. But we know so well that the indigenous people have never had an issue with environment. They live in peace with their animals and all that. You start telling them to move out, you are bringing in something called carbon credits and all that, and now they are not understanding. Yes, there is a benefit. They are benefiting, but let them be involved. Let them know why is their land being used because of this. And the government has to come in. We don't need to have, yes, the NGOs are doing a very big job, but they are helping the government on things they can even do it themselves. Even the environment and land courts, they can go down to the community and explain to these people in their own language on what are the effects and what are the consequences of all that. So for me, that is what is happening in the conservancies and the community. Yes.
Thank you, Ms. Paseina. Thank you, Ms. Paseina. We stand guided on the name. We are pressurized for time. We still have questions that we want to ask the panelists, but so that I don't hog all the limelight, I want to go here first and ask those who have questions, so that we can have the panelists answering them before I ask any other question that I may have. I will give that row one. Anyone who wants a question to ask? There is no one. This row. Anybody with a question? Yes, my brother. Yes, you can ask your question. And you say your name and the person to whom you address the question.
Good afternoon. My name is Ryan Gitahi, and I have a question it's one question, but it has two sides. One for the private sector and the other for government. So yesterday, Mr. Odhengo said that they are going to revisit any carbon agreements, and Madam Pasinei has talked about those land agreements. So if the government is always on the back foot, what is that going to mean for investors? Because aren't investors going to fear that now their investments are not going to be safe? Because if it is this same government which approves leases, which approves land transfers, and then it comes and says that, no, this is not proper, then what does that mean for investors?
Thank you, Ryan, for that question. I think, Dr. Wambua, you will try and deal with that one. Any other question? Yes, Judge Mutungi?
I'm not a judge.
Sorry?
I'm not a judge.
Oh, sorry. I was not pointing at you. I was pointing here. All right, you can ask your question then.
Thank you. I'm Shundu Humphrey.
Yes.
I have two questions, please.
Please make them short.
The first one, probably I'll direct it to you,
Yeah.
because when you are inviting panelists from the private sector,
Yeah.
you said that knowing Kenya the way it is. So my question to you is, because we strongly believe that our only savior in this country are courts, but we have this assumption that we know Kenya the way it is. As judges, how will you ensure that the common mwananchi is secured from that assertion that we know Kenya the way it is when you are making your judgment?
Thank you.
Number two is about goodwill. To my best of my knowledge, goodwill is subjective, depending in which context you are taking. As judges, when you are making your rulings, how do you treat goodwill? Thank you.
Judge Anomolo, I think you'll take those questions. We have Judge Nyagaka, then Judge Mutungi here.
Thank you. My name is Judge Nyagaka. Mine is not a question, but I have heard from the panelists that they keep saying they will partner with the courts have to do something. I just wanted to throw the ball back to the panelists and everyone that ours as courts is to receive disputes and adjudicate on them. We will not come to the ground to tell you file cases and then bring them to us. Otherwise, we'll be biased. So it is upon you to synthesize the communities, to synthesize everybody, that these are issues that are, that are live and which must be adjudicated upon by the courts. Then your role also to the courts, as you also partner with us, is to actually do capacity building. In the sense that, for example, Daktari will come from the university with all the knowledge on amicus about the carbon credits and take us through real class learning, so that when this matter comes before me, I appreciate there are many things that we struggle about, and yes, we are learned friends, but in those areas, be sure we are not learned. We need that expertise to come. So I also would want to suggest that any of the NGOs that deal with this, when you hear of one or two matters, we may not necessarily advertise, but when a matter touches on an issue that you as NGOs or any other party has knowledge on it, just apply to be enjoined as an amicus so that we benefit from this knowledge out there and actually now use it to make a decision that benefits both the community and the, everybody at large. Thank you.
Thank you. Thank you, Judge. We have Judge Mutungi here.
Thank you very much. As always, I speak for the people. And my sympathies for Basina. I'm the judge of the marginalized in Mandera, Marsabit, and
Garissa.
And Garissa. And I have some concerns about the way conservancies actually get registered in those areas. The problem is wider than Basina and Dr. Wambua perceive it. The community land, most of the land there obviously is not registered. Under the constitution, it is now vested in the counties. At times you find the counties are the ones who talk to a few people, the county governments, and then there are letters generated. So I think one of the things that Wambua and the other people can do is to actually get the Community Land Act actualized so that community interests are noted and recorded, so that they have a basis really to negotiate with these people who come and want to take 10,000 hectares as a conservancy. So I don't know what you will do about that, but it's something for the government and the county governments to do.
Then I wanted perhaps Dr. Wambua to respond. The Climate Change Act, what has been the problem in actualizing the setting up of the National Council? Because, as you see, the National Council has very elaborate functions. The appointments are so elaborately set out. The people who qualify. Why are we, is it 9 years, 8 years later, the council is not there? Then how can we say we are doing climate action? I don't know. Maybe you may be able to tell us.
Thank you. I think Ms. Pasaina and Dr. Mbua have noted the questions.
Thank you, Speaker. I have the mic.
Yes, yes, please. Go ahead and make it short.
My name is Dixon Kidenji,
Yes.
working with World Vision Kenya as climate change and carbon specialist. And with me is Philemon Kimosop, our market system advisor. I'll go straight to my question. The legality and constitutionality of the existing carbon projects in Kenya. We have the Climate Change Amendment Bill of 2023 and the regulation in place, signed by the cabinet secretaries. Now, all these projects are supposed to get the letter of no objection from NEMA. Does it mean the current carbon project that we have in Kenya are not legally, are not approved by the national government, and they need to be reapproved again and entered in the National Registry for Carbon? The second question, if you read the regulation on carbon markets in Kenya, which was approved this year in May, it talks about two types of carbon project. The nature-based carbon project, the land-based carbon project and a land-based carbon project. The land-based carbon project have been given 40%. The 40% is supposed to go to the community. The land-based carbon project, 25% is supposed to go to the community. My question to the panelists, Jacqueline, I know we have met with you, is how do you quantify this 40% and this 25% to ensure communities, as Pasina said, are not taken advantage of? Thank you.
Thank you, Mr. Mayor. You'll note that. Yes, we have this gentleman here.
Thank you. My name is Masek Mipuki from Narok. I have a question in regard to compensation on damages caused by pollution. So I just wanted to ask how do you assess the degree of pollution and the amount of damages to the victims and restoring the environment to its pre-damaged state? So maybe Justice Madam Ann could elaborate on the degree of damages, especially to the people living downstream who actually have nothing to do with the projects or whichever has caused the pollution.
Thank you, Meshach. Any last question from this side? The gentleman there.
Thank you very much. My name is Jeremiah Juma Rambo. First, before I ask my question, I have two questions. Okay, thank you. Kwanza nita sympathize na judges, especially those ones who could not.
Sorry?
This technology thing. And I sympathize na judges, especially those ones it reaches a time when they could not make judgment based on how they feel things, but based on the order from the above. Mjua hii Kenya tumezidi na mambo ya order from the above. My first question, we know carbon credit projects often take place in countries, especially developing countries. And when we talk about developing countries, we are talking about Africa, mara nyingi, si ndio? But you find sometimes the benefits that accrues from the projects rarely reach the local community, especially when a time comes where the plant, a large renewable energy need to be installed. And yet, you see our system, especially here in Kenya, mambo yetu ni mbaya sana kwa sababu unapata wakati kesi imetoka, order from the above, hata judges wenyewe wakati community wana come together and they tend to rule that thing. Unapata hata hao wenyewe wanakuwa na threats. Now, as a system, what can we do in order for these people when you go down pale hivyo, every time whenever there is a project, hizo benefits zinawafikia, kwa sababu kuna kilio sana, especially whenever a plant inataka kuwekwa kubwa, kuna kilio sana. Secondly, we do have companies that do buy the carbon credit. Na unapata sometimes the project that they come up with mara nyingi huwa haifiki standard, but since wanatumia the carbon credit thing, wanataka kuendelea kufanya nini? Wanaendelea na hiyo shughuli. Now, what can we do to that? Because I believe Kenya tuko na policies, but now enforcement of the policies becomes the problem. You find that
please make it short. Last question.
You find that these companies usually mislead the communities and also the stakeholder without actually producing what they're supposed to be producing. Yeah.
I will ask Mr. Jaswinta Bedi to take those questions. But a point of correction, I'm not aware of any judge who takes orders from above, my brother. So don't make that a generalization that judges take orders from above. Thank you. Okay. I will ask the panelists to take 2 minutes, please, to ask questions, to answer the questions. I don't know, I'll start with Judge here. Please let us try and make it short. We are running out of time. Thank you.
Thank you for the questions. I've taken 2. How do you assure Kenyans of fairness and integrity issues and the issue of goodwill? You know, judges in Kenya, we are under the Commonwealth, and the Commonwealth system we adopted requires that we have adversarial. We have the person who has been sued and the person who is suing. Mwenye ameletwa kotini na mwenye amemshtaki. So that means you are in the middle, like you are 2 football teams playing. So as the referee, you don't go to which side. Each player, each team has to do their best to score. So that means when you come to court, because it's adversarial, it's not inquisitorial. I know some of us have watched a program called Judge Judy, where the judge, harasses, is this what take place? So you are allowed to get into the arena and ask for information. In our system, we receive information and make a judgment based on the information that has been presented. That means that when you are coming to court, you really have to prepare your case well, and when you come to court, you are still allowed room in between to source for evidence, so that when you come, we don't come to deal with sympathy that you know for a fact that there's pollution going on. So I don't take the step of the prosecutor to start saying this is what is going on, because the other side also has a right to fair hearing. And the law allows us under Article 35 to source for information from the government agencies that are supposed to provide that. You can do a letter, maybe to the company that you want information regarding this, what they are doing about, maybe you think there's pollution. You can write to NEMA for some of the reports that are done. You can write to forestry, all the agencies, or even the the private sector for the information that you have to build up to your case, by telling them this is what is going on, what has been done. So under Article 35 of the Constitution, you can do that before you come to court. In terms of when you know something is going on, maybe a company that is not meeting the quality standards, you have a right to take action. You don't wait for someone else to do it. Under Article 22 of the Constitution, again, everyone is allowed to bring a case to court where there's a violation of a right or a likely violation of a right. And Article 159 allows us not to dwell in terms of, like if you're supposed to come by way of petition, you have come by way of a plaint, so the case will be dismissed. So how you'll experience fairness in the courts is how much you presented the issues before the court, which then makes the other side to really respond to the questions that you are raising. But if you bring, of course, as a Kenyan, as someone interested in the environment, we know what is going on. But now when it comes to hearing, because you are a referee that is supposed to be impartial, you don't try to break the rules, the regulations of having each party to have a fair hearing, because you know this is going on, and yet the parties did not bring documents to support that. So that's how sometimes you find that we know a developer is, whatever is going on may not be supported by the ecosystem around that place. But because these parties have not brought something that would help you anchor your decision to stop that activity, it becomes difficult for you to do. Remember, they're also Kenyans, or the investors, they have a right to present their part. So if they present something that looks to have been done, you know, for instance, that public participation. Sometimes when the EIA process takes place and the community are approached to ask to give their views, when you're giving the view does not mean that the decision is going to, the project is going to be stopped. But the proposals that you're giving probably makes the informed decision that when these people are going to do ABCD, then they are told that you must ensure you probably put nets to reduce the falling objects harming people around there, or at least reduce the noise. Don't work on Sundays when people are at home. Make sure you finish work by 5 p.m. You know, those kind of guidelines. That does not mean that when you gave your views, then the public participation was not sufficient. So the public participation, again, sometimes you find it say that we are not going to contribute unless this project is stopped. Then you don't give an opportunity, you don't give yourself an opportunity to participate. This person will say, we gave notices, a meeting was called, but they decided not to give their views. So you can't force, like you can't force me to give a view. If I've given you an opportunity to present your case or your view and you've not presented it, the law assumes that you got that opportunity to do it and you did not do. So when the case comes to court, you'll be wondering why the judge is allowing that project to go on, and yet according to you, the public participation that took place, your views were not taken into account. So you know, we need to have an objective overview when some of these projects come. Like probably the conservancy issues that probably comes, a few community members will be interested and would participate, and those are the views that will go. The others will not give it as a priority. Probably they think, I can't leave my work to go and give those kind of views and I'll not get money. You know, like putting a benefit that if I come to that meeting, I waste my time, what will I go back with it? Those are some of the challenges that come with where now finally the matter comes to court. Then you think the judge gets an order from above, and yet we did not do our part in terms of collecting the information or asking for them without doing it. The other question that was asked is how do we assess damages? I'll give an example of a road traffic accident victim. When you get injured in a road traffic accident, maybe you've broken a knee or an ankle, or you just have bruises. There's a way that the doctor will assess that permanent damage to this will be maybe 10% or it's minimal. So it's on that basis then we'll say that probably 100,000 will be sufficient compensation. If it's something that requires even future surgery, then you'll make a reasonable figure that this money will be sufficient to assist the person continue with treatment, because it's an injury that is continuing. It's not like the person has gotten healed by the time they came to court. So it's the same thing when we are talking about assessing damages in terms of pollution. We look at it that when this person stopped, was the harm that was caused, did it end there? Or did we have like a future environmental health hazard that are likely to happen? I'll give the example of the case I did in Owinokuru, where we had the lead poisoning. One of the things that in the doctor's reports was that these people needed to be put on treatment to reduce the lead levels in their blood. And so that means that they already, by the time that the evidence is being presented, there'll have been evidence in terms of how much treatment, how much the supplements cost, and all those kind of things. So you'll put the cost of that sort of treatment that will leverage in reducing the harm that is likely to persist for a while. You know, like when you talk about oil spillage in an area, after the cleanup, we know that when it rains, there's some part of it that you cannot really clean. It will take time to flow with the water. So that means the likelihood that probably people will still be drinking that kind of a situation. So we have the estimates based now on the evidence that will have been presented, where you give compensation just based on the harm and which harm has ended, or if it's something that is continuing, then you also say that these damages for loss already suffered and this amount of money to take care of maybe future treatment or future rehabilitation of the area. If it's a fire that a neighbor's fire probably burnt your trees, so we'll be taking into account issues like how much the tree seedlings that would help you to the cost of replanting, and if there's anything that you are using that probably has been affected. So immediate, in terms of compensation, immediate, and if it's something that requires to go on a little bit out of that. So usually based on the evidence that would have been adduced, courts are able to deal with it. The last one on constitutionality or otherwise, again, that depends when the matters are brought, and depends on what documentation the government gave them. It's not automatic that because there was no regulation in place, that probably it becomes illegal. If there were, like we say that law is never in a vacuum. Like when we had the 2010 constitution and the old constitution, we had what we call transitional clauses. We say that until this become into effect, then probably this will be the governing policies or regulations. Thank you.
Thank you, Judge. Judge is my boss, so I can't stop her. She's also my shemeji, and you know what that means in Luoland. She can prepare me some good ugali and omena once in a while. So I can't stop her. But for the others, I think in terms of time, let us try to be very brief. Ms. Parseina, was there any question for you? Please say it in 1 minute, answer it in 1 minute or two.
I think we've heard orders from above. I need to make it very, very clear and short. But on a serious note, I think we are all learning on the job, as I would call it. And what I would strongly suggest is, and as KEPSA, we've actually, with the World Bank, in partnership with the World Bank, we've developed, and that all of us are, like I said, learning on the job. To me, in my mind, don't be shocked because of the strong carbon agenda and the strong philosophy that our president is carrying on the international stage, where he talks about carbon neutral, he talks about green manufacturing, he talks about 92% of our energy mix is already renewable and hydro, and that means then his plan is that Kenya goes to become the first country in the world to be 100% using 100% renewable or green energy. I don't think it's an impossible task. We're in 2024, we've got 6 years. We are all used to running and being first on the international stage, whether it's a London Marathon or the New York Marathon. And I think on this carbon marathon, we will also be first in the world, and we should be very proud of it. We've got this strong agenda of growing 15 billion trees. There's a whole thinking that by 2032 we'll grow that, but it's all to do with us leading the world into the change and not being led. So I think all I want to say is that somebody talked about how are you going to manage greenwashing, what can the private sector do differently. And I think the private sector, what we're going to try to do is we're going to start instilling values of self-regulation. Because if I can instill value of a self-regulation in you and tell you that if you go this route, your price will fall down, and if you go this route, your price will go up. Because a lot of people will want to then start naming and shaming and policing, self-policing, purely because if I participate in a greenwashing situation, and if it's an isolated one case, that isolated one case will have an impact on your carbon credit price, because it's not a universal price, right? It's not like a coffee or a tea commodity price that it's controlled by global markets. No, it's controlled by your local ecosystem and how you're managing your ecosystem. And I can give one example of self-policing which has worked in Kenya in a textile and apparel sector. I don't know how many of you know that one of our largest exports to the US is apparel, and it's about $500 million. Last year it was $470 million. In 2004, we found 17 containers that came into Kenya from China, and they were label production. They had labels in the goods were ready. They were coming into a factory in Mombasa, and all the person was supposed to do is put "Made in Kenya" label on it. So it was a transshipment that was happening through Kenya, because Kenya under AGOA is allowed duty-free to the United States. So there was a lot of duty saving by transshipping goods unethical trade practices is what I was talking about. And I was at that time the chairman of the Kenya Association of Manufacturers. I went to the site with our minister at that time, and there were two decisions we had to take at that time. What do? We've compounded this cargo. It's 17 containers. It's a lot of jeans. They were going to a very large retailer in the US, and the KRA was suggesting, oh, why don't we do not allow this to be exported, but we can sell them in the domestic territory, so we don't transship these goods into the United States. Obviously, they were looking at a revenue implication that they would make a lot of money by selling domestically. And my view was very different. And I'm happy to say that the government did listen to my view. And my view was we should have a big bonfire. And at the port of Mombasa, we had a big bonfire. We burnt all those brand new jeans, 17 containers, but we were making a statement. And the statement was that Kenya only practices ethical behavior. Kenya behaves with self-regulation, self-policing, and from that day onward, never has any US customs authority doubted the integrity of our revenue authority, because the lesser of the two evils was that if we burn, we will get the credibility that we want. So I just want to add there that we should be looking at it positively and not negatively.
Thank you, Mr. Bedi, for that. Before I move on, I'm told the owner of motor vehicle KCU 044. KCU 044, your vehicle is being stolen. Please, if you mind about it, please check it out. The make is not given, but the KCU 044 is about to be stolen. So do something. Ms. Kimeu, you have you asked something? 1 minute, please. Then Ms. Pasaina, then we can come to Dr. Ambua to close.
Yeah, I think in 1 minute about the quantification of the benefits for communities. I think World Vision, we are in the same box. I wish the Minister of Environment was here to answer that question, because even before we go to the question of quantification, what are we quantifying first and foremost? Because, for example, for non-land-based, projects like improved cook stoves, ideally we are supposed to calculate carbon from at the place where the improved cook stove is in operation. But what are we getting currently from the project developers? They are calculating carbon even when the stove is not in use. So even the credits that we are getting are not really what we are supposed to get. So there is a lot of work that needs to happen around ensuring that we don't have double accounting, and also there is a lot of transparency in the carbon market. So that question about quantification is very key, and I think we can discuss it further even with the Minister of Environment, because they are very key to also advise us, and also us to advise them on what needs to be done around that. Yeah, for me, I think we need to really look into those aspects of ensuring that we don't have double accounting for carbon credits, and there is transparency in also the carbon credits that we announce, for the project developers. Thanks.
Okay. For me, I think it's just recommendations on what is supposed to happen. We are already hearing about there is a quantification on how it should be calculated. Just imagine the community does not even know about that, on how you do those calculations and all that. So for me, my recommendations are we respect the community rights to land and water. Let us have proper documentation, because most of the indigenous people and pastoralists, like the Honorable Justice have just said, proper documentation. Which land are you going to put this project? Is it a community land? Is it a leasehold title? Is it a freehold title? Which land tenure are you dealing with? If it is a community land, let there be proper documentation before this project take place, before even the agreements are signed. Let the land documentation process be done by counties and government, because I think that is where the whole of this confusion is coming in, because the government and county will come and say, look, this is a public land, this is a community land, yet the community don't understand. So let us define documentation first before we even do all that. Let us have fair compensation. Explain to them how do you calculate those carbon credits. They will understand, because they are the end user and they are the benefiters of all these projects. Let there be fair compensation. Number 3, let be fair participation. Let them participate, take their views, listen to them if they have any question, because they are the ones who will be affected by all these projects that the government is working on. The final issue is about let there be prior consent. Consent, nobody should force you to make any consent. If they are not understanding this public participation and even what you are talking about, explain to them more and more, because they end up, actually what usually happens, they first book these lands, they give people documents to sign. That means you have already blocked your land from any other investor. Why do that when these people don't even understand all the issue about consent? Let consent issues be done to these indigenous people to understand. Even the conservancies, the lease agreements they are doing and all that, these people are on somebody else's land, meaning you have signed a lease, you are just a leasee. The lessor is there, and you can't do anything to that land according to the law without informing the lessor, who is the owner of the land. But it's the other way around. It is the lessee negotiating without even the lessor knowing. Let there be prior consent in all this, and let the community be engaged. That is all.
Thank you. Yeah, I have 6 questions to respond to. So, Judge, yours will be last, just to bribe you. So first, yeah, on transition, I think the question that was directed to me has been responded to by Justice Omolo. Just to emphasize, read the carbon markets regulation. I think regulation 38 provides for the transition process. So, yeah, no project will be thrown out arbitrarily. Second response is on capacity building. I think that was a concern from Justice Nyageka. Yeah. Yeah, we need to adopt, I think, a whole society approach to building capacity. Nobody can claim to have 100% knowledge, not even us in academia. Every year, we keep learning new stuff about climate change, about carbon markets. So ourselves, private sector, communities, we need to engage everybody so that all these issues are understood. And I think if we do that, then we shall move together forward as a nation. Then on Community Land Act, yes, I agree with Justice Mutungi, yeah. And there are some NGOs that are already, they are doing projects on mobilizing communities in those arid areas to have their land registered as community land. Because once it's registered, then it kicks into motion safeguards. For instance, having community land committees, entering into agreement, establishing constitutions for those group branches, etc., yeah. So I think it's important. This needs to be escalated. Then the question on the Climate Council, why it's not become operational 9 years later. I think the problem, I think, it's political, and it's I would say our political culture. We tend to undervalue participation of non-state actors. And the cases that have gone to court basically are on the appointment of non-state actors. The appointing authorities have not followed the procedure. I mean, if the initial law had said, let the non-state actors appoint their representatives for gazettement. Then the government decided, no, we will appoint. And the president, the president will then gazette. So, so there was a problem with that procedure because the civil societies were saying, no, we know our representatives better. Let us nominate and then let them be gazetted. So the government went around, changed the law, and said now it's the cabinet secretary to appoint from those stakeholders. So again, that provoked fresh litigation. So I look at it as a problem with our political culture. If we can change that culture, make our governance structures more accommodative for non-state actors, all these structures will become operational. Then for benefit sharing mechanisms, yes, it's true. Land-based 40%, non-land-based 25%. somebody can raise a justiciable issue, yeah, on where is the fairness. Why apportion 40 here? Why apportion 25 there? So for me, I look at it as one of the disputes that could emanate from implementation of the carbon trade regime. Then it even gets worse. Projects on private land have no obligation to have in place the benefit sharing mechanism. So that also tells you, I mean, who's capable of doing a carbon credit project? It's only those who have huge tracts of land. By the way, 1 metric ton of carbon, to capture it, you need half an acre. Stock it up with trees, let them mature, hold them for about 25 years or so. Yeah, then you'll be guaranteed of getting the equivalent of 1 ton of carbon. So who's able to do that? You need quite some land, right? Is it the poor? Is it? So if you do it on private land, so why should we exclude you from benefit sharing? I also see that could provoke also litigation going forward. Then lastly, Judge, your question. I see you've not stood. Legitimate expectation. Why do civil society and activists go to court to challenge a development approval process? Is it that they don't want development? Is it that they are anti-private sector? I think for Save Lamu, that CBO went to court. Not that they didn't want coal, the coal project. All they were saying is that the approval process for this coal project did not follow the law. And many times, that's what people say. That's what people do when they go to, of course they know when these projects are implemented, there will be other benefits. But if the process is not followed, and coal, by the way, can be extremely polluting, yeah? The more reason why we need stringent approval process for such kind of technologies. And I'm not saying that that pollution cannot be sorted out. I mean, 80 years ago when we discovered nuclear energy, of course we couldn't deal with the impacts then, yeah? But now, at least we're able to do, and that's why nuclear plants are increasing, as we were told in the morning, yeah? Because there's a way we can now manage some of those risks, yeah? Not all of them, most of them perhaps. So probably the same case with coal, yeah? So it's not that people are saying no to development. Actually, sustainable development requires that we balance economic issues with social issues and environmental issues, yeah? So, and let's not criticize those who go to court. I mean, they have a right to. But also, let's educate everybody, like I said, a whole society approach in raising awareness. Let people know that development has also to comply with the law, and particularly environmental protection standards. That's all I would say. Thank you.
Thank you, thank you. I think we have had a very useful conversation. Don't we agree so? We don't want to stand on your way to lunch, and I think our time is up. I was looking for Judge Nzili to give us some nice congratulations to these ladies and gentlemen here, but I can't see him. Princess, do you want to? Huh? Okay, then if the people I wanted to give us a clap are not there, I will lead. There are 5 of them. I want us to do a factorial clap. We start with 5, 4, 3, 2, and 1. Aya, kwe tayari? 1. Thank you very much. Thank you much. Hand over to my chair. She has been harassing me here about time, and now I think it's good to let her take her time. Thank you. Thank you.
Thank you very much. Another clap for our very good panelists. I think very rich, you agree with me? Very, very rich panelists. Just one announcement, we have been asked to go for lunch now, then we reconvene at 2:40. So almost 50 minutes. Number 2, if you look around yourselves, especially those who are sitting here, there's something very dangerous. We have live wires. Our team, we have Judge Olao still shaking. Yeah, he was almost electrocuted. So he's still feeling the tremors in his body. So please take care, but we are going to ask them to see if they can bury them under the red carpet. So we take care of that. I think we are going to have a very, very serious issue. Kindly. But as you are walking out, please make sure you step out very keenly. So see you at 2:40. Thank you, and good lunch.
Hapo.
And yeah, people, let's start thinking what we're doing. Don't let nothing change your mind. Let's start heading homeward bound. Get off the ground, stop losing, yeah, losing. Keep rising to the top. Give it all you got. You gotta wake up.
first time. I won't be responsible for my actions. It's too late to change your mind. I'm gonna keep you coming all night long, and I'll be there to always comfort you. Our love so strong, it can't be undone. No, 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 baby, baby. We'll be together as one. 'Cause I
Sijui mahali kamera iko. Leta. Unachukua na yako? How will they know?
Umepiga? Zimekuwa mingi?
Good afternoon, ladies and gentlemen. Good afternoon. Hello, everyone. Let's make our way back to the dome. Let's please make our way back to the dome, all of us. Thank you. Let's all make our way back to the dome. While people are making their way back, moderators or session chairs, I'll give you 3 minutes each to just give us a wrap-up of what transpired in your sessions. So please be ready.
I know there's
Kindly let's get back to the main dome. Kindly let's get back to the main dome. Ladies and gentlemen, kindly let's get back to the main dome. We'd like to do a wrap-up of all the sessions that we've had. Let's kindly get back to the main dome. Let's all come back. Let's all get back to the main dome. Let's all get back to the main dome. Thank you. I'm not too sure whether it's my voice that is making you come back or it's the rain. But either way, I'm happy to see you coming back. Wait. Hold. Are we ready for the afternoon session? Are we ready for the afternoon session? Okay, let's all rise. Let's all rise. We need some energy in this room. Just a little energy. Let's all rise, please. We're going to do Clap for yourselves. Clap for yourselves. Thank you. The mic is not good. All right, thank you very much. We are going to go into the afternoon program. But before we get into the sessions that had been planned for the afternoon, I would like us to have a recap of what happened, what transpired in the breakaway room. This is important because there are those who went to a different room and they would like to know what happened in the other room. So we had 3 sessions: interlinkages between gender and climate justice, artificial intelligence and application in geographic information system in the judicial decision making, and we had a theme on climate change and natural resource management. I'd like to call the moderators or the session chair to just give us highlights of what transpired in your session. In no particular order, one of the chairs or moderators would like to know what happened in that session. So highlights. Thank you.
Good after lunch. Good after lunch. My name is Engeli Brian. I was one of the moderators, or I was the moderator for the session for the role of AI and geographic information systems in terms of their role in supporting judicial decisions. We did have a very interesting session whereby we not only learned from our expert panelists, but also we had real-life experience being narrated by our judges. So it was quite a very interesting session. We did come up with a few recommendations, we'll call them resolutions, that I'll be able to share with you. And one of it is that from the experience that we are able to see the role that emerging technologies and AI is playing, it is important for us to continue embracing AI integration, especially in the judicial system, so that it can help our judges make informed decisions around environmental justice and related matters. It is an issue that we can't run away from because it's technology and we have to embrace it. Secondly, there was an issue around limited capacity of the judiciary in terms of the capacity and skills of the officers involved. And one of the recommendations was that we continue engaging experts in other or in the technology field on need basis, even as we continue to build the capacity of the human resources in our judiciary. Thirdly, there was also an emphasis on embracing multidisciplinary learning and partnerships. It was actually a point that was emphasized by majority of the panelists, and this would ensure that we not only segregate technology or AI as a program on itself, but integrating it into other programs as well, so that we have lawyers and other judicial officers that are conversant with AI and geographic information. And lastly, we had a recommendation on developing and reinforcing or refining our legal systems or framework to ensure that we have a basis for our implementation of technological advancements in our judicial system. Our legal framework as it is, it was acknowledged that it does not sufficiently address the challenges that exist, and therefore there's need for us to strengthen that. Lastly, we had a reassurance from our judges that in as much as we are embracing technology and AI, their decisions are not prepared by ChatGPT and AI. It is human-based. The technology can only help them to make a decision or arrive at a decision. However, it is our responsibility to ensure that we embrace technology so that we can catch up with everyone else globally, and ensuring that we attain fairness, transparency, and accountability in dispensing climate justice, as well as addressing environmental related disputes. Thank you so much.
Thank you very much. A more warmer round of applause, please. I was in this room and I remember one speaker said several times that orders from above. Now, when I've heard him say that the judges have assured us that ChatGPT is not the one making the decisions, it is them making decisions. So I want to interpret the ChatGPT as orders from above, just to take care of my brother, but I know what he meant. Anyway, let's go to the gender team. The gender team, are you ready? The moderator or the chair of the session. Interlinkages between gender and climate justice. I'm going to make you an active audience until he comes, until he gets there. All of us, until he comes, until he comes, until he comes, until he comes. I'm seeing some of us sleeping, so I'm just trying to make us an active audience as well.
Thank you, my sister. Let me call our rapporteur to come and give us the resolutions. What about that? Oh, I go back there. Where's our rapporteur? Yes, here she comes. Can you start clapping for her until she arrives here? Okay, let's have our moderator. I was the chairman. Let's clap for our moderator until he gets here. Judge Kebuja.
Okay, until he gets here.
Here, not there.
Oh, he just wants more claps, so keep clapping.
Yeah, you can go back.
I'm trying to trace whatever it is that we were discussing. Shortly, I will be there. We had a very engaging session and a very lively panelist. And we had a discussion on the space of gender and climate justice. The highlight of what I will give you is generally what was discussed. I'm almost there. Yes, we were dealing with we were exploring the connection of the gender and climate justice, the challenges, and proposing actionable pathways. And we were taken through by the first presenter was Justice Dr. Millicent Odenyi. She took us through what climate change, the LAD code, the environment LAD code, what we have done regionally, nationally, and internationally, and the connection between the decisions that we make, the space for the women and the girl child, and the justice in the climate change. There was a very lively discussion on how we maintain the impartiality when the decisions that are made by the various courts that are gender sensitive, we maintain the impartiality when ensuring that the judgment speaks to the gender issue. And she assured us that gender is not just the women and the girl, gender is everybody. And all we do is to ensure that we speak to the circumstances of the case in accordance to the provisions of the law that we all know, the international instruments and the regional ones. And the space is there. She made a challenge to all of us. And the feeling in the room was that we needed to do more to ensure we address the issue of the culture. When we talk about the women and the girl, we remember the culture where they come from, the influencing factors. Because in some cultures, when we talk about the women and the girl being light holders, in some communities, they are not encouraged to think so. It's like they are being given a privilege to be there. We were also taken through the issue of the budgeting processes that speak to the issue of the gender and the women specifically. And one challenge and one resolution that we came up with is to ensure even when we are doing our budgeting processes, and this was specifically to those of us who are involved in the budgetary cycle, to ensure that we have something we have budgeted for to speak to not just the issue of climate justice, but we bring in the gender in the climate justice. What activities as a station? What activities as a judiciary? What activities as the ERC do we plan for in a financial cycle that will speak to this very important issue? And especially to bring this information to the communities where we come from, to the communities where our courts are stationed, to the communities that we interact with in our official and in our personal capacities. We were taken through by other presenters on what Oxfam stood for. If David is still here, you can engage him. He told us about how he speaks for 24 countries in Africa and the interconnection between the various activities in those countries and what the space for the women, the girl child is in climate change and what can be done to make them feel more appreciated. When we were told earlier on about the FROCA, we were told it's even in the world level. But how effective have we appreciated the women, the girls, in the decision making at that level? The ward, the sub-county level, the county level, the national level. Do we really consider what their suggestions are? Or they are just there to add to the numbers? We were told of a situation where they are only present to sign that attendance form for purposes of auditors. But do we give their recommendations, their presence, the importance that it requires to have? And the other resolutions that I was not able to capture, but my chair was trying to call the rapporteurs. I believe they captured the more detailed, and will be reflected in the document that we shall discuss, I believe, tomorrow. With that, I present my session's recommendations.
Thank you very much. Told you, we are going to be active. So until he gets down. Thank you very much. The good thing about this recap is just for us to understand what transpired in the sessions, but tomorrow we are going to have a complete recap of the whole day, so do not feel like you missed out anything. So the people who are here, the climate change and natural resource management. Climate change and natural resource management, either the chair or the moderator. You can give them the Obama wave until you can give them the Obama wave as you come. Yeah, you can give them the Obama wave. Keep waving, keep clapping for him. Let them use this one.
Good afternoon, friends. I was not a rapporteur, so I may not capture what we did, but I know what we discussed. Our session was about climate change and natural resource management. We were taken through the Paris Agreement and Article 6, which allows countries to trade on carbon credits. We had a panel of 5. We missed the presence of the State Department for Environment and Climate Change. There was no representative. We had a panel consisting of Lady Justice Anne Omolo. We had Ms. Jacqueline Kimeu from WWF. We had Mr. Jaswinda Bedi from Kenya Private Sector Alliance. We had, I think, Dr. Wambua Kituku from the University of Nairobi. And we also benefited from Ms. Soinei Parseina of the social justice activist NEST. Our discussions were basically around the area of climate change. Justice Omolo took us through what the Environment and Land Court, how the Environment and Land Court has leveraged itself in handling cases on carbon compensation or compensation for carbon credits. I think what came out was that so far we hardly have cases on carbon credit. Those that have been filed are probably awaiting resolution. I think from Dr. Wambua Kituku, we came to learn there are about 5 active cases that may be there. She took us through the jurisdiction of the court and how the court has would handle matters of compensation and how we arrive at matters compensation. Ms. Jacqueline Kimeu took us through how WWF has leveraged with communities in certain areas and the challenges that people face in those communities in context of carbon markets and resource management. I think what we discuss in that area will most likely be captured by the rapporteurs. And then I think Dr. Wambua Kituku took us through the carbon cases that we have. And the resolution was there were not many carbon cases in court. We discussed about the kind of remedies that are available to us, maybe orders of mandamus, orders of compensation that can be given by the court. Mr. Jaswinda Bedi from the Private Sector Alliance was tasked with telling us how the private sector intends to, or how they intend, how they will measure greenhouse gas emissions, the reduction of greenhouse gas emissions. And he told us that the most important thing is that they follow the carbon footprints so that the credits are awarded. As at now, this is something that is in the making. He assured us that as a sector, they would try to do, to be very ethical in how they measure the carbon credits. And I think that is a point we took home. There was a major concern, especially from the communities, as was put by Ms. Kimeu and Ms. Parseina, about how do the communities benefit from this carbon, the so-called carbon credit agreement, because it happens that majorly in the pastoralist areas and conservancies, the conservancies would enter into arguments on behalf of the communities. The communities hardly know what has been discussed, and then they find themselves, they have entered into an agreement for 30, 50 years, mortgaging their land or something like that for these communities, for these conservancies or other people who want to trade in credit, or in carbon credit, and they do not understand what arrangements they are getting into. There was also the concern that how do we know exactly whether these carbon reductions are happening? Because we have carbon registries where people indicate what they are doing in terms of carbon emissions. There was the issue of greenwashing, where people just go and say, this is what we have reduced from the environment, and they have not done so. So there was an issue of verification, audits, of how do we audit that this has happened? How do we achieve what was called climate neutral or net zero emissions? We need to be certain that for us to enable us to achieve the net zero emissions, we agreed that we have to have a way of balancing what the carbon dioxide that is produced into the atmosphere and what is extracted from it. I think that was majorly our discussion, and I thank you for listening.
Thank you very much. When I hear you talk about people understanding, being a media person, I also ask myself, are we planning to work with the media to disseminate information, to let people know what is happening? And I like the bit, I particularly like local FM stations because they talk to people in the language that they understand. So that is one of the things that we can think about, incorporating media, and especially local media stations, to have these conversations so that people can be able to call in and ask questions. We have an expert there who can respond to the questions in the mother tongue, and they understand better. Thank you very much. Ladies and gentlemen, let's appreciate our presenters. I am meant to send you out to the breakaway sessions. My middle name is Cherobon. Cherobon means rain. I was born during rain. So if I go with my middle name, I will not have a problem sending you. But I don't want to go with my middle name. So this is what we are going to do. We have 2 sessions. We're supposed to have one here and one in the breakaway room. I suggest that we limit the time. We work with about 40 minutes. We have the first session, and then we have the second session, all of them in the dome. Is that okay? Fantastic. Honorable Lady Justice Annette Nyukuri, the stage is yours. Until she gets here, the Obama clap, all of us, until she gets here. And you do it with a smile. Until she gets here. Somebody is not clapping. Until she gets here, I am seeing you. All right. Thank you very much.
Okay. Thank you so much. I was telling you that I would give you a new name and call you Nafula, which means rain, from where I come from. This afternoon, we want to look at AJS. Just a moment. Yes, we want to look at AJS, that is Alternative Justice Systems, the place of AJS on the environment and land cases in the country. We know that under START, one of the components or what we have underscored is multi-door approach in access to justice. We all know that only 21% of disputes are filed in court. 79% are determined outside court, meaning that the community is better placed to resolve disputes than through resolving disputes through litigation. So this afternoon we are going to have a conversation around how we can use and apply AJS to address, to deal with disputes. Remember that the people have the sovereign power under Article 1 of the Constitution, and that power is exercised through delegation to the organs of government, one of them being the judiciary. So the power I exercise as a judge is delegated authority, but the people can decide they don't want me to exercise it, and they can decide to exercise it themselves directly by taking the authority to determine their disputes, because sovereign power belongs to the people. Article 159 shows that we are supposed to consider that judicial authority must ensure that there is promotion of AJS, Alternative Justice System. We should be able to promote that. So this afternoon we are going to look at that at length or deeper, and we are going to have the objective of this conversation is to explore the role of alternative justice systems in resolving environmental and land disputes, promoting equitable access to justice, and enhancing community participation in sustainable resource management. We are no longer doing things the old way. There is community involvement in what we do. That's why we have CUCs. We have a lot of interaction with the community. So this afternoon, we are going to have 5 panelists. That's Lady Justice Christine Ochieng, Dr. Steve Akoth, Ms. Helen Tuey, and Dr. Kotut, who are going to address that issue. The moderator for the session is Dr. Joseph Wamwara. I want to welcome the moderator. Let's give him a hand as he comes. Yes, continue clapping until he reaches here. I was asking him this afternoon that when the teacher is younger than the student, I was a student in 2020, 2021. He taught me, when I was taking my master's in environmental law, he taught me jurisprudence. So he's a big man. Thank you, Mwalimu. Karibu sana.
When your student is bigger than you, you learn respect even if you're a teacher. Now, I want to start by presenting apologies from Dr. Akoth. There's an event that is happening somewhere in central Kenya that he had to attend. So he has sent his apologies. But I also want to start by saying, in this region, we have rainmakers, and therefore, if rain interrupts your program, it is because you did not consult the rainmakers properly. And therefore, then we are to blame for this. With that, then, I also want to have the privilege to welcome the panelists here. We have Honorable Justice Christine Ochieng. Justice Karibu, Karibu. Let us welcome Honorable Justice Christine. And then I want to confirm to you also that Honorable Dr. Kotut was called back to the office urgently, but he's on his way back. I also confirm that Helen Tuyue is on her way back. She also had to deal with an emergency. So today it's just going to be a conversation between me and Justice Ochieng. And we don't fear engaging in that dialogue. And of course, we will also call in the one who was named Cherobon Nafula today to just chip in even as we discuss. So yes, I will take my seat. But before I take my seat, I think as a preliminary issue, and now that Justice Christine Ochieng says she's holding brief for Dr. Koth, I want to ask her to introduce us to AJS. And there was a time last year when they developed this 12 commandments of AJS. I don't know whether you remember Professor Ngugi's 12 commandments of AJS. But introduce us to AJS, then we go into the details of the questions that we needed to handle today. Yes, and finally, my apologies. I remember that we also have Honorable Grace Sitati as one of the panelists. My apologies, ma'am. My apologies. My apologies. Karibu sana. I am growing old. Asante. And with that, then, I don't know whether you will come or we just use the mic. Introduction to AJS, and then we go into the details of the other questions. Thank you.
Okay. Good afternoon. I know it's a dull afternoon. I wish I was a rainmaker. I would have pushed away the rain. But we have to make do now that we've been told that by Nafula that is the way it is. So I just want to give a brief overview of AJS. AJS is Alternative Justice Systems. And it's the reason why the judiciary has embraced AJS is because we know for sure all of us in this room, we are Africans. And in the African setup, be it among the Kalenjins or the Luos or the Luyas or Giriamas, they all had a way of resolving their own disputes. And these disputes were resolved so that relationships were restored. And that is when, before I joined the judiciary actually, in my previous life, we had an interaction with Professor Ngugi, who by that time was in the Kenya Judiciary Academy. And he called upon all the partners who were involved in access to justice to just come and share what were the alternatives. And because we appreciate that not all disputes end up in court. And because of that, and based on the various researches different partners had done, they came. A committee was formed called the Alternative Justice Systems Committee, the National Committee, which now has transformed into a secretariat. And this committee just oversees the different types of how communities resolve their disputes. And by communities, I don't mean only the traditional communities like our ethnic communities, but there are also communities in the towns. There are communities, church communities, most communities, the communities are diverse. Even within the Moi University, I'm sure that there's a student community and there's a way they resolve their disputes. And there was a research that was done when they were developing the AJS policy that revealed that actually 68% of disputes are resolved by the community. They don't come to court. Only 21% of the disputes come to court. And there was a development of what we are calling the river of justice, where they were demonstrating how, where there are disputes, there's a very wide river. But parties come, some people resolve it in their family, among friends, in church, in the mosque, but some people also opt to go to the pastor, etc. But very few actually go to court. But as the river flows towards, I believe, the end, that's when parties resolve to go to court. But what you need to remember is that the reason why judiciary has embraced AJS is because it's a lot of disputes are resolved much faster. The saving of costs, relationships are restored because parties are able to explore and restore and resolve their disputes based on the areas where they live. And the judiciary has actually anchored from the year at the bit 2021, anchored AJS in what we call the STAG, the Chief Justice's strategic framework. Or now we are meant to enhance access to justice. It's anchored in STAG. And AJS is also is anchored within, we borrowed under Article 159(2)(c) of the Constitution that says that we have to actually embrace all the traditional forms of justice. And I know there's been a confusion about AJS and ADR. ADR is actually a smaller subset of AJS. AJS is the alternative justice, the bigger spectrum on resolving all forms of disputes. And arbitration, mediation, conciliation, and the rest are all fall under AJS. That's what I can say as an introduction. Thank you, Prof.
Even as you rest, I know you are prepared to tell us how AJS may be used in the ELC courts, and whether you'll also tell us whether we have used them, we have embraced AJS as a form of resolving disputes in the ELC court. But in the meanwhile, let's have Honorable Grace Sitati, the Deputy Registrar in charge of court annexed mediation. And the question that I would want us to address and more is how court annexed mediation has embraced AJS, and if it has been used to help provide solutions that uphold justice and fairness for marginalized groups, including the different gender groups, including the indigenous communities and all. Welcome, Honorable Sitati, and wow us with the great things you do at the court annexed mediation. Thank you.
So good afternoon. Where I was in the gender conversation, we were talking about urinals. Clap for urinals. I know you don't know why I'm talking about urinals. When you go to different urinals, you will not find the urinal for a child and a tall person. And I'm complaining because, I mean, you can see I have good height, and this thing, and, but clap for me. I have made it. And then the second point I'd like to make, we were talking about Nafula. But in secondary, we looked for a rain god. But right here is Honorable Grace Nasike Sitati. If you ask me what Nasike is, it's locust season. Where are the lawyers in the house? So around here, kuna watu wanaangalia hiyo mvua, and they are looking at an opportunity. Yaani ile locust itafika saa ngapi waingize kwa mdomo. Clap for all lawyers. What is mediation? You'll see me fidgeting with this. It's part of the game. So mediation is actually what we do in our everyday life. From negotiating for bread. During this holiday season, we have children in the house. And if you are like me and you love crust, you have to negotiate and tell your child, kesho usiamke mapema, hiyo crust ni yangu. So mediation is just negotiating between parties with the aid of a mediator. Do we have the mediators in the house today? Please stand up, we clap for you. We want to recognize you. She is also a mediator. Ladies and gentlemen, these are the neutral mediators who will help us not to come up with a resolution, not to determine the matter, but they'll help us to talk to one another so that we can resolve the issue. Hawana nguvu ya kukata kesi. Kazi yao ni ya kufanya mimi na wewe wenye hatuongeleshani, hatuangaliani, tuweze kukua katika hali ya kuongeleshana. So we appreciate you. What are the statistics from 2016 to date through the program of Court Annexed Mediation? And what is Court Annexed Mediation? Would like to know that that we have judicial officers, we have judges. They have been referring cases to mediation from 2016 to date. Would you believe that the judicial officers themselves believe that 23,519 cases were good for mediation? Would you believe that? And yet statistics tells us so. And even the better piece of news is that the successful rate is that the mediators were able to resolve 11,049 cases, which marks a 51% settlement rate. Me, I thought sasa hapa ni gelegele, ama muniski? Or we are too formal to clap and dance. I saw you doing. You can clap for mediation. Another good thing about mediation is that 62.1 billion that was previously locked in litigation was released to the economy. And apart from that, we have children matters, family matters, where you cannot put money value, but we have relationships restored. Isn't that good for mediation? Now that is court annexed mediation, the 21% that go to court. Ladies and gentlemen, we have something we call private mediation. And I'm happy to see Madam Teresa Mugaza and Shiro. They were there in Masabit when the Honorable Chief Justice launched the private mediation guidelines. Because we have been talking about court annexed mediation. This case has to be in court. But now we have something wonderful called private mediation. What is private mediation? Ladies and gentlemen, you do not have to have a case filed in court. But these mediators that you saw us recognizing can actually be the people that make you not go to court. You know, you choose that door and say, I choose mediation. I will take this mediator, that is two parties, will choose this mediator and have their case resolved before going to court. Clap for mediation. Why is the private mediation a game changer? Remember, we've been struggling with where the 79% have been going. We know there's the community leaders resolving cases, but now we are introducing to you qualified mediators, should you choose that be the forum you want to use. Look at the conversations we're having. When you are driving down maybe Eldoret or Nairobi, you will see stalled projects. Maybe, if you think about it, you'll say, maybe ni pesa hawakuwa nayo. Reality on the ground is that they have a case in court. So why can't we encourage that before even you go for that injunction in court, why can't we have conversations around what is it, what is your interest in this thing that is almost becoming a dispute? So that is what private mediation is all about. Lady Justice talked about the subsets of ADR, and I'll invite you to read the Article 159(2)(c) of the Constitution. AJS and ADR are all what? Forms of dispute resolution, and that is Katiba, isn't it? That is what the Katiba tells us. And if I'm to interpret the question by the moderator, sorry, I was excited a bit. I had to talk about mediation. Forgive me. Now I go back. What are the interactions we can have? Strategic interactions between AJS and Quarter-Next mediation. If you have been watching the television sets, you've been seeing us going around launching ukumbis and Quarter-Next mediation suits. Has anyone not seen that? Marsabit, Isiolo. But what is that building if we don't protect the sanctity of the processes that go there? Those are conversations we have to be bold enough and have them. So in Isiolo, we had AJS launching the Code of Ethics, and there's a Code of Ethics as well for mediation. I'll talk about mediation because I know we are very bold on the principles of autonomy. Let the parties self-determine their cases. Because once the parties come to the mediation suits and we start imposing decisions and outcomes as mediators, then we'll have the parties running away from the entire process of ADR. They will not know whether it's called AJS or mediation, but that single experience by that user will make us lose very many people who would have chosen that door of ADR. So we have to be very intentional about protecting what is going on in the ukumbis and in the mediation suits. In Quarter-Next mediation, we have feedback mechanisms. We have the QR codes, and that is one thing maybe we can also, I want to say, in fact, AJS, you'll forgive me, sometimes language in the afternoon has a problem. Feedback mechanism, you have gone through the process of mediation. You want to give feedback that this is how I was treated in the process of mediation. You give that feedback, and we get it and we act on it so that we can improve that process in the ukumbis and in the mediation suites. Ladies and gentlemen, we had conversations about participation of women. In mediation, in 2016, we had women mediators at 47%, and the men mediators were at 53%. But I want to say that in the year 2024, we have 50.6% women versus 48.6% men. Ama ni mimi ndio niko na shida? Can we clap? So we are seeing it shifting, and because we know next year men might be more in terms of mediators, we are happy because we are embracing what? Mediations, isn't it? The second point of my question is towards capacity building. What are we doing? We have had TOT programs. You will see, maybe if you look at Facebook, our Facebook pages, you'll see we are doing TOT programs. We have trained 60 mediators because Grace Itati cannot be able to talk every day. We have 60 mediators who can in turn train our 1,032 mediators that we have in the country. We also have webinars on emotional intelligence. I did speak about feedback mechanisms. What we got as feedback from our users, and that is the community, is that mediators are impatient sometimes, maybe from the things we do at home, or the issues we are dealing with as mediators. Have you ever seen a problem come before you and you're actually facing it? Because we are saying mediators are just human beings, we now have to take them through the process of what? EI, where we sensitize them on cultural issues and so on and so forth. The Honorable Chief Justice also did guidelines on family mediation, And we also have guidelines for private mediation. So these are areas the mediators or even the elders can look into. We have other upcoming ELC activities. Now that is very relevant to us. We have a summit in April 2023, just to discuss what role mediation can play in resolving of ELC disputes. And then we also have activities building onto the summit. For instance, we have the Inns of Court, just looking at mediation. And then, of course, the bar bench activities and so on and so forth. In the issue of marginalized community, you might not see it in Facebook, and we do not like to brag maybe, but let me brag because I'm here. Kibera, we all know what happens in Kibera. On 29th of November, we are going to have mediators, and we are going to have Honorable Makandere sensitizing the community on how they can use mediation to resolve the disputes in the communities. Please clap for me. Thank you very much.
Thank you very much. We have clapped. She has referred the disagreement we had by my not calling her out as for mediation. I hope we will identify a mediator here to help us resolve our dispute. Now, thank you very much, Honorable Sitati. I think now I want to go back to, and for the temptation not to, so that I can catch your eye, I want to ask that we continue here, the next part of the question. Has AJS been effective in reducing backlog? Number one. Number two, at the ELC, have we had instances when we have referred people and to AJS, and how effective have those referrals been? Thank you.
Hello. Thank you, Daktari, for your questions. On the first one, whether AJS has been effective in ELC, I'll give an example, and it's something I personally participated in. It's Kajiado County is one good example, and I'm happy that Judge Gisheru continued with the work. That there were so many land disputes in Kajiado County. And a lot of the land disputes, some of them involved families. And as we know, for most of us, especially the students, that Kajiado County is one, the land ownership in Kajiado County is mainly through the group ranches. And with the group ranches, these are different communities put together so that they are registered as members of the group ranches. Then they are given portions of land through what we call an area list. And there were a lot of disputes because the officials of the group ranches were many times shortchanging some other members who are not very empowered by giving them less parcels of land as opposed to what they were entitled to. So these cases found their way into court. And they'd been in court over a long period of time, even before the ELC court was established. So as we were grappling with these matters, because they used to come to court, I send them back, they can't go down, and the reason why we kept on saying that it's the communities who would be very entitled. So we had we had a discussion with the National Land Commission and also the Kajiado County government, and we realized that it would be important to find a way if these issues can be resolved within the communities, by the communities, because the elders actually knew who owned what, as opposed to the younger people who are just making lists and saying that these are the official, these are the members of the different group branches. So they came together, and with the help of the judiciary, the AJS, the first teams were formed. And for the Maasai, there are different groups of the Maasai. The different, they call themselves, you find, like, for example, in the area of Kitengela, it's called Kaputei. There's one called Olgulului. There are different group branches. So they came together representing the respective group branches. The people who had a history of the respective group branches came together. And when disputes came before the court, which were before the court, as a judge, I was there by that time, I used to send them to these groups. By that time, they were not fully structured, but the county government used to give them space. And when they came with the decisions from wherever they had sat and agreed, we used to record them in court as consents. So that way, it was actually much easier. And I realized that a lot of these matters, actually the parties never appealed. And that means that they were happy with whatever the decisions were. So this was now structured, but by that time I left and my colleague Judge Kerry continued. And as you say, and I know for sure that a lot of the ELC matters, a lot of the land matters we deal with, some of them have a history even dating back to maybe the 40s and the 30s. So there are many times my colleagues, when we have discussions with my colleagues, they say we send them back to the community. Even the ones that the issue of the adjudication processes, you find the community members who know who was living where the graves were, or which family was living where, so that they go and discuss it at home. And that is not before a mediator. So when they have that discussion, that is what we call in HJS autonomous. They have their own systems of resolving to an autonomous way, and they come back to court and we register them as consents. I know one of our colleagues, Judge Mwanyale, around Kapsabet has done quite a bit around it by recording those consents, and we just continue to work. So I can actually say that the ELC court has really embraced AJS and will continue to embrace it so that we may be able to implement the stage. Thank you.
Thank you very much. Let me ask, can you hear me? Thank you. I just want to follow up, yes? Do you see that AJ, are there instances when, or you foresee situations when we could also incorporate climate change issues in these forums? Do you think you will need special training for those who make these decisions, or we will go to the indigenous knowledge of these facts to help resolve these issues? Do we need any extra training? Do the people who make decisions at AJS need extra training to understand to understand climate change and help resolve disputes emerging from it? Maybe just a minute or two, then we. And
Okay.
Chair, if you want to chime in anytime you do, please.
Okay, thank you. The answer can be yes or no depending on what we are targeting. Yes, in the sense that these are emerging issues. Climate change is an emerging issue. The effects, especially for issues of adaptation and resilience, there'll be conflict for sure. Especially where you find perhaps the river has changed its course. The parties are fighting over might be pasture because of there are no rains, so the pastures are they're limited pasture. Crops are not growing very well. So I believe that there'll be conflicts emerging therefrom. So it will be important actually to inculcate AJS in climate change issues. And more so, as I said earlier on in my introduction, that AJS, that means that it's only the community resolving disputes. The disputes can be resolved by the banks, by companies, by like the issues we're talking about the issues of carbon credits. These are issues that conflicts for sure will arise. We can't bury our heads in the sand. Conflicts are especially more so where we'll feel that maybe the officials are actually eating more of the cake than the community members that are not eating. And there's just some thought that came to my mind this morning. I was just thinking, in areas that it really rains very heavily, like in the forests, we know for sure that the communities living there are not responsible at all for all these challenges because they have good weather, like for example, the Marakwets and the rest. So you see when someone comes and says they want to buy carbon of the whole of that forest, I mean, by the time the community members discover, of course, conflicts will emerge, and we'll actually have to maybe embrace it just because we know for sure that the court matters will take long. And then maybe the issue of the issue of experts might be assessing the amount of amount of compensation that is required, and might be even the issue of sharing out that compensation to the community so that it befits the people who actually grow those trees. Thank you.
Very true, and we can come back to Honorable Sitachi, and this will be a yes or no question, and it's from, do you actually train mediators? Do you actually train mediators? And if you do, could we schedule one for my students? Because I want them to, when they get out of here, they're already caught next to mediators. Thank you.
Okay, thank you. Thank you for your question. For mediators, they need to undergo a 40-hour training, and we have a list of institutions who give that training, but I can put in a good word for the students of Moi University because I'm a Moi University alumni.
Bless you. And thank you very much. The very last question to you probably would be, how much of the cases you handle, would you know if they are environment related, or they may be, what percentage of those are land and environment or climate change disputes handled at court annex mediation? Would you know?
So, if I'm thinking about it, because when the cases come referred from court, remember they come as ELC case number 1 of, say, 2024. So we have not gotten to that point where we separate the two, that is climate, E and L. But yes, that's something we can look into in the future.
Very well. I think, I don't know if Helen arrived or Dr. Kotut, so that, Helen, please, welcome Helen. I gave instructions that you should be brought in directly. Karibu Helen. Okay. Helen, I don't want to introduce you, but I want to ask that you take a minute or two introducing you yourself. I know you're a teacher, and at least you have a teaching background, and then tell us a little about what you do at the county. Thank you.
Okay. Thank you very much for this opportunity that I've been given. My name is Helen Tuwei. As you've seen me, I'm visually impaired.
You could just keep sitting. Everyone of us is sitting.
Sorry.
Oh, sorry. You can sit if you wish, or stand. Yes.
Sawa. Thank you very much. I think, as you have seen me, I'm visually impaired, but I was not born visually impaired. I got my disability when I was at a younger age of lower primary. But nevertheless, I proceeded with my education. And as you've heard, professionally, I'm a teacher, secondary teacher, Kiswahili history. I'm an alumni of Kenyatta University. Currently, I work at National Council for Persons with Disabilities as a County Disability Services Officer, was in Gishu County. And welcome all. This is my area of jurisdiction. And thank you very much. So I work as a Disability Services Officer, and National Council for Persons with Disability is a semi-autonomous government agency that was started through the Act of Parliament, and in 2003, and now it was mandated to carry out all the services of persons with disabilities to champion for their rights, social, economic, and political in all aspects. Thank you very much.
Very much, Helen. I'll ask you, just sit down, then you can talk as you speak.
Thank you very much.
And I have a follow-up question. We are talking about climate change, environment, and dispute resolution. We are wondering, how are you involved in helping persons with disabilities resolve their disputes? Are there instances when you have had to help them through the court process? And have there been also instances when you have helped them go through the alternatives to going to court, probably alternative justice systems or mediation? Thank you.
Okay, thank you very much. Issues that I come across in my office, you understand our persons with disabilities are vulnerable, and in Kenya, very many things have not been, they are not disability inclusive, but I appreciate that at least we are trying in terms of inclusivity. Yeah, I've come across several issues. Somebody may be battered because of disability, somebody abandoned, or somebody is chased out of the family because of some disabilities. I think all of you understand that disability is something that our community doesn't embrace it quite in a good way, but they take it somehow like it is a curse. And therefore, our persons with disability have been discriminated in very many ways. So these issues that I've been receiving on disability, maybe discrimination or injustice, I've been referring to the various departments, like the labor department, when there is somebody that has been chased out of the work. I've also encountered a case where a person with disability was terminated in doing his or her work because of getting her disability. We've really tried that one, but all in vain. We did that one, but it was not in a good way. The person was not absorbed back or reinstated in the work. So it has been a challenge.
Very well, thank you very much. Maybe just one last word on, I know that I attended a training where you were teaching us a few things on how to live and support those with disabilities. Maybe one thing that I know most of us do not know about how to handle persons with disability. Just one lesson for us, so that members of this conference can take one lesson on how they will handle persons with disabilities.
Thank you very much.
Thank you.
First, I want to tell our audience that disability is one thing that can make you join that club without choosing. You can just find yourself. And when you find yourself in that situation, it is just to accept and move on. So as you handle our persons with disabilities when you are moving around, just take as a person like you. Wear the shoes of that person with disability, if at all it was you. You understand our persons with disability, for example, let's say me. I'm giving an example as me. If I approach a certain office requesting for employment, obviously majority they'll say maybe going to beg. And that is a notion. Let's take our persons with disabilities positively. Let me give an example of a day. I went to an ATM. Then I found a police officer. I asked him to assist me to withdraw my money. Then what that man told me, just go, sina leo, kuja siku ingine. So that is a notion. Amejua nilikuwa naenda kumuomba. Sikumwambia, nikamwambia, mimi sikuwa na kuomba, unisaidie pesa. Nimesema kindly assist me to withdraw my money. Then now that is when he understood that I was requesting for an assistance of withdrawing my own money. When you see the persons with disability, they are not beggars. Not all of them are beggars. But when we treat well, we take them to school, they'll be positive in our life. For example, you can go to a family where none of let me give an example of my home. I'm sorry to say this. In my home area, back in Kericho, I became visually impaired in the year 1995, and after losing my sight, majority told my mother that, hii imekuwa useless. Kama nyumbani usimpeleke huko, utakuwa umeharibu pesa yako. Na ukimpeleka special school, huko tu ni kuharibu. Then what happened? The SNE or the EAC officers came to my family, and then they advised them to take me to a school. After then, in fact, in my village, I think I was the first lady to join university. And in my home, I think I'm the first person to be employed. And I'm now the backbone of my family, despite the challenges that I have. So I say, let's treat our persons with disability with a lot of dignity, as the way our Constitution states, Article 54. Let's go all and read. Let us not treat them in a demeaning way. Because sometimes when we get into a venue like this one, you'll find somebody telling you, uko, niko wakubwa. Usiingie. Because they have judged you with your disability and maybe not your capacity in your leadership. Thank you very much.
Very well. Thank you very much. Let me get the thank you. Thank you very much, Helen. I know you. Time is what has stopped us from hearing more from you, but you are an inspiration to many of us. I know you prepared very well, and probably Justice Christine Ocheng, one word that you have not said, and your parting shot. Yes.
Okay, my parting shot is that it's important to embrace AJS. Do not underestimate AJS. Because with AJS, because we know for sure that right now, even filing court cases is very expensive. The legal process is complex. The laws are complicated for people who are not they're not the legal field. So please try and embrace AJS, because AJS, the disputes you'll resolve, when you resolve the dispute, you'll restore relationships. There'll be no enmity. But the moment that you have a decree against somebody and there's a judgment data, you'll for sure be sworn enemies, even if you are twins from your mother's womb. Thank you very much.
Very well. Let us appreciate Justice Ocheng. And then we have Honorable Sitati. I hope there's not been protocol here, so I hope that's fine. Go on, yes.
First of all, we need a mediator. He forgot to call me out, but I've forgiven him. You know, in mediation, you can say, I forgive. I have forgiven him.
Thank you.
I just looked at Judge Nyukuri and I forgive him. Now, parting shot. Prevention is better than? Yeah, that is what you should always remember. And I want to say that private mediation is a game changer. Even before you come to court. Remember, court annexed mediation, we were filing a case in court, then the judges were referring. But for private mediation, you can sort out your issues, okay, through a qualified mediator, and the courts are ready to adopt that judgment, to adopt that settlement agreement as an order or judgment of the court. Clap for mediation.
Yes, and clap for Honorable Sitati. And with that, I want to wish, thank you very much for listening to us. I know you are committed here by nature. You've listened to us. And then just one last thing to the AJS process. Engage the universities as well. Over to you, Chair and Justice Nyakuri. Thank you.
Thank you very much. Haven't they done a good job? Yes. Can we give them a clap? We have learned that mediation, conciliation, and all the other dispute resolution mechanisms that are not litigation, the alternatives, are as good and if not better than litigation. So let's embrace those systems. We've also learned from our sister Helen that disability is not inability, and they don't need sympathy, they just need accommodation and support that would enable them access. It's about accessing, isn't it? We want to access justice, we want to access climate justice, land justice, environmental justice, and we must put in place facilities and accommodations for all of us. We have said that we are not leaving anyone behind. So it has to be all inclusive. Thank you so much, our moderator. Thank you so much, Judge Christine. Judge Christine welcomed me when I was going to Machakos. I am so grateful. She has taught me so much about AJS because she's always very keen on that. And Honorable Sitati, thank you for that. I can see mediation is running in your blood. Let's give them a hand as they step down. Keep clapping until all of them have left this place. Thank you so much. Nafula, it's your turn. Karibu.
Thank you very much. She said we clap for the rest, but let's clap for her as well. Thank you very much. And thank you, the moderator, for keeping time. I truly appreciate that. When we talk about alternative justice system, when Honorable Nyukuri called me Nafula, I said it is okay because today morning I learned that there is where you are born and there is where you are cooking. So where I am cooking is the Nafula part, so I'm okay. So I am home. And then how many of us here, apart from the person I know, are 70 years and above? 70 and above? 70, 75 and above? 75 and above? So ladies and gentlemen, I told you where I cook is Luyaland, and where I cook, when we go to the radio station, lazima tutumeko salamu. Ningependa kutuma salamu kwa mama yangu mpendwa, Paulina Choge. Just wave to mom here. She was around in town and she said she wants to come and see what we are doing. And she's one of the greatest mediators in the village. I remember when I was young in campus and running for office, student politics, even in the village, and they would come to me and tell me, Kanjula, we would like this and that. And my mom, when there is a problem in the villages, she's the Kanjula. She's the person to talk to. So Sitati, you have a champion here who has not gone to school but is sorting out problems in the villages. A clap for her, Mama Paulina. Thank you very much for making it here. All right. So we go to the next session. And I would like, ladies and gentlemen, this one we're going to make it special. And the reason I'm doing this is because I do not want us to sleep. So let's all rise. Let's all rise. All right, put your hands together for Lady Justice Grace Kemei until she gets here. Until she gets here. Ladies and gentlemen, Lady Justice Grace Kemei. I want to see your smiles as well. And you open your eyes a little, just like mine, to be sure you're not sleeping. Okay, she's taking her time, so still clap. Still clap until she gets here. Thank you very much. She's going to tell us what her session is all about. Please be seated.
Thank you very much. Good afternoon. Thank you, Nafula and Mama Cheroban, for attending this session. We are really glad to have you here. From where I come from, a function without rain is not a blessed function. So in as much as we are a little bit inconvenienced, we are really blessed. Now, this is session number 8, and I would like to call my panelists and the moderator. This session is being moderated by Lady Justice Nelly Matheka. A big clap for her until she sits down. Justice Nelly is a lady, so she has to walk slowly. Next is Mr. Justice Eboso. Ms. Teresa Mugadza. Why are you tired? She hasn't sat, and she is a lady. Brenda Waithaka. Miss Brenda Waithaka. Mr. Elijah Lempaira. I hope I'm pronouncing your name well. Welcome. I don't know whether we have anyone representing Lady Justice Maureen Onyango from the Labor Court, Employment and Labor Relations Court. And of course, the privilege to welcome Dr. Francis Atwoli. Any representative from that office? Welcome, yes, there is somebody from that office. The Secretary General of KOTU, very powerful office. Your brother Atwoli, you're representing Brother Atwoli, that's what I have heard. Welcome. So the theme of our session is the just transition in the context of climate change and labor force implications. And the objective is we expect the discussants to talk to us about what just transition is and how crucial it is as an enabler in the implementation of net zero transition and response to injustices. One moment. So I think from yesterday, from the beginning of the conference, we've heard about strategies to transition ourselves to net zero carbon, to transition ourselves to low carbon economy. And the objective of this session is how do we transition communities, individuals, having in mind issues like fairness, inclusiveness, equity, and considering the social, economic, and environmental realities of our space. I will now invite Justice Lady Matheka to take over the session. Welcome, my lady. You'll have to use this one.
Good afternoon, delegates. As you heard, my name is Justice Nelly Matheka. Mimi ni jaji wa mashamba na mazingira kutoka huko Mombasa. Nimeleta salamu za watu wa Mombasa. Hamjambo? As my sister judge has told us, our subject for discussion this afternoon is about just transition and as regards to climate change and labor force implications. Now, I would like somebody to tell us what just transition is. Our students behind there, what is just transition? Anybody knows? Hamtaki kusema. Now, anyway, nitawaambia. Just transition is ensuring that nobody is left behind, you know, when it comes to the transition to low carbon emissions and an environment which is sustainable. So that this is what we'll be talking about this afternoon or this evening. And ILO recently gave us 3 pillars on what is just transition as relates to workers, and that is employment creation, social protection, and rights at the workplace. So you see that there's a relation between climate change and workers. All of us here are workers or employers or employees, so we are affected by this just transition. So just transition is nobody should be left behind. To start off our discussions, I'd like to ask the judge, Judge Eboso, to comment on the intersection between labor and environmental law in the just transition and sustainable development context. And when you do this, please take us through nationally and globally. Karibu, Judge.
I have been directed that I could very well sit and use the portable mic. Good afternoon, delegates. My name is Justice Bernard Eboso. I am a judge of the Environment and Land Court based at Thika in Kiambu County. I'm happy that Judge Matheka was able to tell us that we are talking about a different transition, because initially, when I encountered the topic, I thought it was transition from the earth to heaven or hell. But I can assure you that it is not transition from the earth to hell or to heaven. I have structured my presentation into 5 parts. First of all, I want to request to know I have how many minutes so that I confine myself within the minutes. I have 10 minutes. I'll be looking at briefly at a contextual background to the question. I'll try to define what net zero is, because you cannot talk about just transition without addressing the definition of net zero. I'll revisit the definition of transition. Then I'll look at the key principles of just transition. I'll comment on the international legal framework on just transition, local framework on just transition, and then I'll conclude my remarks. We are all assembled here because we all recognize that climate change is a catastrophe. It is a catastrophe because it is affecting all of us adversely. And we also recognize that barring natural activities like volcanic eruption, all the other causes of climate change are related to human activities. It is against that background that global players have come together and have said, as humans, as players, we've got to come up with deliberate steps to avert the catastrophe that is called climate change. And one way of going about it is to engage in production models and human activities that do not contribute to climate change. Production models and human activities that lower the amount of greenhouse gases in the atmosphere. Activities and production models that lower carbon dioxide in the atmosphere. We now go to net zero. Net zero is a situation that envisages a scenario where the amount of greenhouse gases or the amount of carbon dioxide that is emitted into the atmosphere vis-a-vis the amount of carbon dioxide that is consumed by what is called carbon sinks, like forests, like oceans, that they balance. When the two balance, then the situation or the environment is described as a net zero situation. And that is considered to be the ideal environment. So, the transition we are talking about is a transition from the destructive production models and the destructive human activities that affect our biodiversity to a model where whatever gases are produced vis-a-vis what is consumed by the carbon sinks that we have, there is a balance, and therefore there is no more increase of green gases. So that is the transition we are talking about. So when we talk about transiting to green production, green jobs, green everything, that is the transition. So I have looked at net zero and the transition. What are some of the key principles of just a transition? Just transition was initially a concept that was developed in the US in the 18th century, and it focused on the rise of workers who were affected by regulations that had been put in place to control water and air pollution. But at the moment, in the context of climate change, just transition is a concept that has been developed and emphasizes the need to ensure that as we respond to the challenges of climate change, and as we put into place mechanisms to transit from the destructive model of production to the more sustainable model of production, we should ensure that we carry along everybody. We should ensure that those who are affected by the transition are a part of the transition, and to ensure that adequate measures are put in place to take care of those who are affected. What am I saying? I am saying if Pan Paper is closed today, as it was closed some years back because of pollution, there were workers, there were people who were working at Webuye Pan Paper mills. What do? You come up with a solution that ensures that you transition from that model of production to a model that offers them alternative employment. So one of the key principles is that economic development, a healthy economy and a healthy environment do coexist. And two, any program aimed at transiting an economy or transiting a community from a certain model of production to a green model of production or to a sustainable model of production should should ensure that proper policies are put in place by national governments to ensure that all the people who are affected are catered for. Now, at the international level, I want to confess that when I was doing my research, I looked around, I did not come across any convention or any treaty that I would say that this is a binding convention or a binding treaty. What I came across were pronouncements by the International Labour Organization to the effect that every government has a responsibility to put in place policy and legislative measures to ensure that those who are affected by the transition are properly catered for. Locally, I looked at the climate change, and I can confirm that a number of sections, like Section 20, Section 21, Section 20 emphasizes on the need to ensure that as part of our curriculum in schools, primary schools, secondary schools, and universities, climate change is introduced as part of the curriculum. Section 25, I think, of climate change. Thank you for now.
Thank you, Judge Eboso, for that detailed presentation on the definition of just transition and the national and global context of the same. Now I would like to move on to KOTU. Mr. Marwa, I would like you to tell us how trade unions are dealing with this climate change transition or climate adaptation. Please, can you share the Kenyan experience with us? And before you do that, please introduce yourself and tell us what it is that you do in KOTU.
Okay, thank you, Honorable Maureen, and also thank you, Justice Eboso. You have done justice defining or explaining what just transition is. So my name is Nashon Marwa. I'm a program officer at KOTU, and I'm here to represent Dr. Tuoli. And before I answer your question, what the trade unions do on matters climate adaptations to mitigate the effects of climate change, I would like to start by listing some of the climate injustices that the trade unions try to deal with as a part of mitigating the effects of climate change. The first of it is displacement of workers. For example, the workers who are in carbon-intensive sector, like oil refinery, heavy manufacturing, mining, what happens to them when we shift to a well-sustainable model? In the recent concluded COP29, we saw the president of Azerbaijan saying the fossil fuels, it is a gift to them. So there is no way you can say it is bad. Yes, it is a blessing, but the way you use it and the way you mitigate the effects of it is the big deal here. Now, the second one is unequal access to green jobs. You get, yes, they are green jobs, but where are they? Mostly you find them in the urban areas. And who does these green jobs? Are there women's? Are there PWDs? Are there youths? Are there marginalized communities? Who is this sect that usually do these green jobs? So there is an equal distribution of these green opportunities. Another one is OSH disparities, occupational health and safety. The people in the informal sector who are being told to shift from the traditional models of production to the new one, they don't get to access these safety gears for them, especially those in the farming industry, those doing agriculture, doing fisheries and stuff. Those are some of the injustices that now the trade unions try to tackle during their activities. Now, some of the things that the trade unions do. The first one, it is trying to negotiate green clauses in their CBAs. They try to incorporate green sustainable clauses that in their workplaces that promote that integrate environmental sustainability in their workplace. Another thing, it is advocacy for just transition. COTU usually lobby for these funds from ILO, Solidarity Center, DTDA. They partner, they collaborate so that they make sure that there is skill and upskilling and reskilling of these workers at these, especially in the informal sector. In the recent, there was another meeting on NDC, and COTU happened to attend that meeting, and it was really advocating in integrating just transition principles in the Kenyan NDCs. And these particularly pointed on matters workers to make sure that the national climate strategies and these NDC, they capture the needs, they capture the interest of these workers, making sure that when you are making these policies, the ideas they are put in place. When you are making these policies, their labor rights are being protected. So those are some of the things. Another thing is building workers' capacity. There are green representative programs where their representatives from the unions are trained. They are given funds to go to the grassroots to train the workers on matters environment and the shift, just transition shift. And also there are workshops and trainings for capacity building so that they are, they have skills to tackle these effects of climate change. Yeah, thank you.
A clap for Mr. Marwa. Thank you, Mr. Marwa. I'm also happy to hear that COTU does training for these workers on capacity buildings on matters of just transition. Next, I'd like to go to a friend of the ELC court. All the ELC judges know Teresa. Teresa Mugadza is a good friend of us. She's the IDLO Climate Justice Focal Person. Teresa is also one of our sponsors, and we are very glad to have you on this panel today. Now, Teresa, I'd like you to comment on how our country is applying the principle of just transition in the context of accumulating climate debt. How our country is applying this principle. Teresa.
Thank you very much, Milady, and thank you for the opportunity to engage. I think I want to go back to something that Dr. Otichilo said yesterday, coming back from COP29. And I want to say this to lay the foundation, I think, for my remark, which will be very, very brief. I think the first thing that we need to talk about, before we even talk about how a country is applying the just transition principle is really to talk about understanding and information on issues of just transition. I know when you started, my lady, you said, would anybody respond to what is just transition? And for me, that speaks to the fact that in the climate discourse, I think what we have seen, both at the level of state parties and governments, and even citizens, is that the information has not disseminated enough. The concepts are not well appreciated. I'll give an example. At the climate summit last year, the Africa Climate Summit, there was a session on just transition and movement from, I think, they were talking about transitioning in the terms of low emission energy. And I remember one woman said, African women are being asked to transition from what to what? Because we're already energy poor. So before you even talk about justice in the transition, you are talking to people that are energy poor. And I think that brings me to my response to the question of how are countries dealing with the question of just transitions. And I think the colleague from Kotu already raised the issue, which is that countries are operating at different levels in terms of how they deal with the question of climate change because of resources, because of where they are in terms of development. So their responses in regard to just transitions are going to be different because of where they are located. So you will find that there are countries who are at a point where just transition in terms of dealing with issues of climate debt, which may be just to take a step back and say, when we talk about climate debt, we are really talking about understanding that there are countries who owe other countries a debt in terms of climate. I think yesterday the panel spoke to it quite eloquently about the fact that for a lot of the developed countries who are able to have economies that at a certain level, at a certain point, they were the greatest emitters, and the rest of the world has suffered along with them, but they have led, as it were, in carbon emissions. So to some extent, when we talk about justice, it's really to say there must be an acknowledgement by those countries that have developed on the back of fossil fuels, on the back of energy that is not clean, to be able to understand that the countries that are least developed cannot move at the same pace in terms of just transitions as they do because of where they're coming from. I'll give an example. I come from Zimbabwe, and in Southern Africa, coal energy is big, and that's what drives industry. So when you expect countries from that part of the world to transition from coal as quickly as maybe other countries in the West are doing, you have to think about where they are coming from and what resources they have. And the impact on labor, I think that my brother from Kotu has already spoken to. You are talking about transitioning, and you still expect the economies to develop. So to what extent are there mechanisms in the global framework that responds to climate change? What mechanisms are there to support those countries that are least developed or are developing to be able to undertake the transitions? So I think the response that we got from Dr. Otichilo yesterday around what has come out of COP29 really answers the question for you, my lady, which is to say that I don't think there is a consensus or a one-size-fits-all response to just transition because countries are at different places. I think Dr. Otichilo said something very profound for me, which is that COP29 could be the COP that defines how countries engage in that space, particularly from an African perspective, because you go there expecting that there will be an acknowledgement of the climate debt that's owed to developing countries. There is no acknowledgement. You go there expecting that there will be commitment to increasing the resources available to facilitate transitions for developing countries. The commitments are not strong, and yet when you leave back, there is an understanding that we all committed to the Paris Agreement and we're all going to transition. So I think the short answer is that countries have not dealt with the question of climate debt honestly, and I think the conversation to have is what are the different levels of development that countries are at, and how can they design responses that speak to the development of their economies, that speak to sustainable development. Transition does not happen in a vacuum. It happens in the context of our economies. It happens in the context of our development. It happens in the context of sustainability and engagement, and acknowledging that those that are most affected have the least resources to be able to transition. So the conversation really should be about how do we get a framework, how do we get commitments that ensure that we are moving at the same pace. And right now, it does not look like that is happening if the COP is anything to go by. I think that would be my short response, my lady. Thank you very much.
Thank you, Teresa. My takeout is that countries that are least developed cannot move in the same pace as the developed ones, and what we need is commitment from these countries so that we can strive to move in the same pace. I'd like now to move on to Impact, the organization called Impact. It's the Indigenous Movement for Peace, Advancement, and Conflict Transformation. Representing Impact today is Mr. Lugadei. Mr. Lugadei, yes, you're there. Mr. Lugadei, maybe you could tell us what are the lessons that we can learn from the just energy transition. What lessons can we learn?
Thank you very much. Good evening. My name is John Stone Lenasalon. I'm working for Impact Trust Kenya, and I work as a program officer, responsible investments, business and human rights. So Impact Trust Kenya, we work to advocate for the rights of indigenous and local communities in northern Kenya. So our vision is actually to create just an inclusive society where everyone has access to justice. And some of the work we do issues on land rights, especially community land rights, and we work with our partners like Namati. We also do advance responsible investments, issues on business and human rights. We also do some programs on adaptation and resilience, and also research. So coming to a just transition is ideally a pathway to net zero while taking care of sustainability, social justice, and economic justice. So it's just balancing climate goals with economic equity. And actually, I can say that just transition is achievable if all the actors perform their duties as stipulated by the UNGPS, that's the state duty to protect and remedy, and also the corporate responsibility to respect human rights and offer also remedy in case of violations. So I'll start by going to general lessons before going to the context of the communities we work with. So firstly, there is issue of, these are new developments, though it's not new as such, but just transition conversations has been recently much talked about because of this issue of climate change. And there is need for capacity building for communities and also the other actors, because it's a new thing. So there is a need to, for example now, going to talk about compensation or agreements. There is this model called FPIC, where communities are required to give their consent before any project starts. Now, there is need to build capacity of these communities, because how can they give consent when they are not informed about giving consent of what? Now there is also that need. In that context also of capacity building, there is need for prioritization of worker transition like reskilling and retraining workers. For example, this is a new thing, and we don't have much experts in this field, especially renewable energy projects, those operators of those big aeronauticals. Now, we also need to get prepared as a country to training the workers so that these available jobs can also be done by our workers in the country. Because for now, we heavily depend on expertise from as far as outside the country. Now, we also have issues on policies and regulatory frameworks. When talking of compensation, you find that there are no clear policies of how it's done. So therefore, or even benefit sharing, there are no clear policies of how benefit sharing is done. So therefore, that calls the need for government to come up with clear policies, enforceable policies that protect the rights of indigenous and local communities that these projects affect. Also, there are these issues of enforcement. These issues of involvement is becoming a problem because yeah, I hope you have heard of Lake Turkana land case, whereby the communities went to court, but luckily they won the case. It's about this issue of involvement, where the investors mostly they don't follow the right process, ethic process, when coming to engaging communities. So there is need for proper community involvement in order for them to actually give consent. And when coming to compensation, they need to be compensated fairly. For Northern Kenya, most communities are pastoralists. So, and for pastoralism, it requires a large area for the communities to be able to make a living, because livestock requires a big area because they move from one area to another. So I think it's fair for them to be given a fair compensation, and not just compensation, also other benefits. Because for so long, these local communities that host these projects, they are just taken as a mere stakeholders. Instead, they should be also shareholders, because they are providing land. They are giving all their land for these investments, for the benefit of the country. And that needs for them also to prosper, for this shared prosperity, offer these opportunities of a just transition. Now, there is also issue of gender. Recently, we held a workshop of women and just transition, women across Africa. Now, we have seen some similar problems where land, because Africa ideally is, our societies are patriarchal. So you find that women are not allowed to own land. So sometimes even these projects affect the individual projects, individual parcels of land for women and also men when coming to private land. But when coming to compensation, we are able to see that women are not compensated well. Also, over these projects, the workers, you find that women are not given the topmost jobs. They are just given these small jobs, unlike their counterparts. So that's also a challenge. And also there are also injustices like rape for the workers. You know, they go and find, they look for jobs, then they will be taken advantage of. Yeah. So we have seen there is that a big problem of gender and gender equity. Now I will come now for the communities we work with in northern Kenya. Now, for the avoidance of doubt, these communities actually, they are so welcoming about this project, this just transition project. They welcome. Because some people think that we don't engage communities because these communities are very progressive. Once these communities are given the capacity, engaged, they are actually welcoming these infrastructures. And I'm saying this because we have worked with them and we have heard their voices. So the only problem here is when coming to involvement. When coming to involvement, these communities sometimes, if they are going to be consulted, they consulted when the conversations have started or the last stages of projects development. So they don't have information of how this thing has initiated and then the whole conversation. So you find them, they will become even difficult to understand these things. So for these communities, they feel the just transition as not that just. They feel that they have been left behind. Why? We have one case study of Lake Turkana wind power project. We did some researches there. We talked with the communities over and over because of also working directly with them. And they were able to say that they were actually not informed. And one of the big challenge is which intensified this injustice was the land there is not registered. Land is still held in trust by the county government. So the project developers just come and talk with the county council by then, and then they lease out the land, and the land is given, and later the community, they don't have say. And that is very evidence because of the verdict that was given by the court that the right process was not followed. Another challenge is land valuation. The land is in northern Kenya is still, or in those pastoralist communities, it's still treated as invaluable. For example, now, the leasing of Lake Turkana wind power, the site for Lake Turkana wind power, that parcel of land, was leased for 2 Kenya shillings, 2 bob per hectare per year. So you can imagine that. And seeing the value of these renewable energy projects, the sun, that this land provide. So we need to rethink of the value of land lived by these communities. Now also benefit sharing. There is no financial benefits. As much as I know, there's no financial benefit sharing by the communities. They don't have power. Those living around there is no power. Then now, if there are no benefits to these communities that give us our land, give us their land for this very important investment, why is just transition there? There is nowhere. Also, some investors or companies think that CSR, there are these issues of CSR, where project developers or investors, they do some projects to the communities to assist them. And normally, they take this CSR like benefit sharing. So when communities try to talk of maybe bringing their issues on justice or on their rights, I told them, see, we are helping you. We've built that school there, we have drilled that borehole. Now, CSRs are not, they are not legally binding. Projects can decide to do or not to do, because those are voluntary things that projects just do out of their will. So now, for land registration, and also because of this renewable energy projects, some counties have decided to politicize it, because currently, now the counties are taking the place to develop inventories so that their lands will be registered. So you find again, some counties decide how the communities do their land registration. But rather, instead, it should be the communities that come up with the best units for them to register their land. Because the idea of this Community Land Act of 2016 is a very progressive act. It's ideally to bring the land management much closer to the communities. But now you find that some counties dictate how communities do land registration, which is wrong. They should just provide they support them or train them, and now later the communities decide by themselves how to do this process. So thank you very much. I think I will reach there.
Thank you, Mr. Lena Solon. We agree with you that just transition is achievable if all actors perform their duties. Now we want to move on swiftly to CALRO, Agricultural Livestock Research Organization, Ms. Brenda Waithaka. We know Kenya is an agricultural country, and we cannot finish this discussion without touching on agriculture. But why is just transition important for the agricultural, food, and water sector? Why is it important? Maybe briefly.
Thank you. So we all know, and we do agree, that for the agriculture and water sector, we are the team that is worst hit or greatly hit with climate change. So for us, from the research point of view, we are working, as we have the dialogue on just transition, we are working with our stakeholders, the farmers and our partners, to ensure that we are now coming up with research solutions that can be able to assist our farmers as they are in the process of just transition. How are we doing this? We are ensuring that we now have the communities and the farmers take the lead in this discussion. For example, when we are doing research in terms for variety identification so that we're able to release new varieties that are adaptive to the climate changes, we are involving our communities, so we are encouraging the scientists to now go and conduct on-farm research, and through that, we now have the farmers take part in this discussion. They're able to assist with the selection of varieties and even livestock or livestock breeds that are the best and are adaptable to them. That will also ensure that they are able to, as they now maybe moved from encouraged to ensure that they move to zero emission, they now are able to also ensure that they are able to make money or affordable some income from these processes. Then also in the process of just transition as an organization in the agriculture and food sector, we are ensuring that we now move in to assist our communities to preserve the ecosystems that are there as we adapt to the climate changes. For example, in Calro, we have an institute that is the Genetic Resource Research Institute. This is the gene bank that is holding our varieties, including the indigenous varieties. And through institutions like Gary, we are able to now come back to the community and assist the communities to now reintegrate varieties that were, or other varieties that will be resilient to the climate changes that we are seeing. So as an organization, we are working to ensure that we build communities that are resilient to the climate changes that we are seeing.
Thank you so much, Brenda. Indeed, we need to preserve our ecosystem. Now, as we make our concluding remarks, my panelists, I'd like us to, just in 2 minutes, to give us the way forward. Opportunity is in the future. What is your organization doing? What can it do? What recommendations can you give to enhance or assist this concept of trust transition? I think we'll start with Mara. Please take 2 minutes.
With the progress that we are making in capacity building, upskilling and reskilling, Kenyan unions have begun to see to recognize the intersection between climate change, labor rights, and environment sustainability. And for that, they are calling for green jobs, policy reforms, investment in training and skilling, so that we can build a workforce that is resilient and adaptable to these changes. Thank you.
Thank you, Mr. Mara. Judge Eboso, what is the role of the court, and what are your concluding remarks?
My concluding remark is that the proponents of just a transition have well thought out ideas that if we transit and we do not pay attention to those who are affected by the transit, then we may not achieve the intended results. I want to say that locally, whereas ideas were legislated to the effect that we would have issues to do with climate change factored in the curriculum as a way of preparing the societies that are affected by climate change on how best to be resilient. I doubt that those legislative propositions have been implemented on the ground. The sooner we do that, the better. Thank you.
Thank you, Judge. Over to you, Teresa. IDLO, how can it ensure that these developed countries remain committed?
Thank you very much, my lady. I think, as Judge says, we cannot run away from the fact that the transitions are happening and they are not just. But we can look to the future, and I think I'll probably say 3 things. The first one is that there is need for continued stakeholder engagement, and at the national levels and internationally, because climate change really is about the fact that we're all interconnected, and we cannot run away from the discussions on mitigation of climate change in our various locations globally, but also I think in the socio-economic strata of society. So stakeholder engagement is very, very important. And what we have done as IDLO is to actually facilitate that engagement. And we've been piloting it with county governments to ensure that communities become part of the discussions on design of locally led climate actions, but also part of climate governance at the local level in terms of beginning to say where should resources go or where should focus be at county level. And I think the second thing really is to emphasize the point for international solidarity. And for international solidarity, but also for developing countries themselves to come up with positions that speak to their realities. I think we have learned from COP29 that Africa needs to have a position that takes into account its diversity, but also its unique position in terms of the impact of climate and the conversations that it needs to take forward into the global stage in terms of climate financing and also mitigation of climate change. And I think finally, just to appreciate and to underscore the importance of implementing the already existing policy frameworks. I don't think we have a dearth of frameworks. There are frameworks, but they are not being implemented. And of course, to encourage climate financing, both at the local level, at the national level, and internationally. Thank you very much.
Thank you, Teresa. Indeed, the climate financing is very important. Mr. Lena Solon, what can Impact do? What more can it do to assist the indigenous people when it comes to this concept in 2 minutes, and what are your parting shots?
Now, from our view, just transition should include a meaningful community, meaningful engagement. That is engaging all the stakeholders, starting from the government and all the strata of the stakeholders, including the local communities, and also getting some information from their local and indigenous knowledge. Also, creating opportunities for our climate resilience and adaptation. And those are the enabling conditions that will enable them to adapt to climate change impacts. Also, establishing clarity on transition endpoints, where all impacts must be disclosed for the communities to understand all these challenges. And for us, Impact, we have been doing a lot of community legal empowerment together with our partners Namati, where we actually train these communities to understand their rights. We also train them constitutional rights. Recently, we have partnered with Strathmore Law Clinic to provide legal aid caravans to train these communities of their constitutional rights. Because we believe that once these communities will get to understand their rights constitutionally, because they cannot even understand, they don't even understand, yet some of these remedies can be found through our constitution, but even they don't know. So we have been training them to get legal empowerment, and even to do litigation whenever they feel they are oppressed somewhere. Thank you.
Thank you so much. Public participation is indeed important. Brenda Calro, what else can you do for farmers to bring them on board on this just transition? Very briefly, and your parting remarks.
Thank you. So for Calro, we undertake to continue developing innovations and technologies that are climate smart for our farmers, and providing them with solutions that will enable them to comfortably transit to the zero emission era. Then also, as an organization, we are working to ensure that the community still is at the center of all the work that we are doing. They are the ones who are leading the conversation. They're the ones who are assisting us to be able to help them to solve the solutions that they are going to be facing with the move to just transition. Thank you.
Thank you so much. Indeed, I think matters climate change are very, very important, and we need to be positive and look at the glass full and not half full and not half empty, as the professor told us in her remarks. I want to thank all my panelists. Apologies to the MC for overshooting our time, and I'd like to hand over to our chair, Judge Kemei.
Thank you, Justice Matheka. A big clap for the panelists. Another clap. Wow. So we have heard from these people. What a presentation. Thank you. I don't know whether I have time for questions. Thank you. Thank you, Irene. So we've heard from our panelists. We've heard from the labor organization, COTU, what they're doing about the workers building resilient communities, retooling, very, very, very important. You've heard from the court. You've heard about the frameworks, the legal frameworks that are available that need to be implemented. You've heard from IDLO. And I think I like what Teresa is saying. We are being told about just transition. And yet, the ground is not level. I think that is very, very important. Our voice should be heard on the table so that we give our position. And that is very, very good sitting at that level, at the international level. We've heard from lived experiences from communities and how they feel that they need more involvement, public participation, to be able to build resilient communities, and also to be able to feel that they are benefiting from their natural resources. And of course, from Brenda, you have told us about smart agriculture, how to embed those strategies, and I like the way you are involving communities so that there is ownership. I know our time is gone, but I would like to just ask if there is one burning question, just one. One burning question. Please help me. Now, because it is a man, one other burning question from a lady, then we will close.
Thank you. My name is Omanyala Richard.
And make it simple.
Yes, very simple.
Yes, please, just one question.
Let me direct my question to Judge Bernard. From where you sit, we have the notion that women cannot have no right to have land, are not allowed to own land. I don't know whether this is in the act that is referred in law, or this is zeroed down to communities and which land in specifications. Is it land, common land from the parents, or land in the country as a person who is called a woman cannot own land? Because as of me, my children have given them land, girls and boys.
Thank you. Thank you. Your question is clear. One last question from a lady. Please put up your hand and give her the mic. Make it simple. I know this was a very interesting session, but because of time, we are not able to take that much questions. Proceed.
All right, thank you. My question goes to Madam Teresa. You have talked about a just transition and the need for the playing ground being leveled. So I was asking whether you think debt for climate swaps would be one way to level the ground for Kenya.
Thank you very much. We will start. Justice Boso will start us off.
Thank you. I'll be brief on the notion that women have no right to own land. I want to say that those who hold that notion are living in the past. Both the Constitution of Kenya 2010 and all our current statutory instruments outlaw discrimination on the basis of gender. Those who have come to our courts propagating that notion, be it in succession courts, be it in the land court, they have left the courts crying because some home truth has been told to them. And I want to emphasize to all and sundry that even in succession matters, a daughter is as much entitled to inherit as a son. There is no law that prevents women from holding land. And because land is an important resource in production, we will not be able to achieve equality in our society unless we intentionally address that issue and deal firmly with those who want to continue entrenching it.
Thank you very much. You can pass the mic to Madam Teresa.
Thank you very much. When you made your remark, I said to myself, the future is in safe hands. And I say that because I am a firm believer, like you, that until we recognize that there is climate debt that is owed to developing nations, by developed nations, we cannot talk about an equal and level playing ground. So indeed, I am a proponent of, cancellation of debt in recognition of the impact of climate change, particularly on developing nations. And given what we are seeing in terms of what the environment and the climate has become because of, carbon emissions. So definitely, that is definitely one of the ways in which the playing ground can be leveled. So a part of me is happy to see that our future is in safe hands. Thank you.
Thank you very much. A big applause for my panelists and my moderator. I think this is a good place to leave it, to end it. Thank you very, very much. I will hand over.
Thank you very much. Wapigie makofi tafadhali. Until they get to their seats. And you can wave the Obama wave as you get down. Yeah? Thank you very much. I will not summarize anything because justice has been done. Honorable Lady Justice Grace Kemei has done it so well. Thank you, thank you, thank you very much. A few announcements. I have a flash disk here that has been found on the ground. If it is yours, please collect it. We'll announce it again tomorrow. Then I'd like to recognize a very important person who has made this, the whole session successful. She's not seen, she's not here, she's somewhere here. Ladies and gentlemen, a round of applause to our sign language interpreter, Edith Chepchirchir. She's done a great job. Thank you, Chepchirchir. We appreciate that. Let me ask you a question before we finish. Don't I look beautiful with this? Huh? Inakaa sambamba. So I'd like you to promote the makers of this. So I am dressed by students from this university. They call themselves their business name is Standing on Beadness. Standing on Beadness. They are showcasing there. They're actually first-year students that have come together and they are making beads. So they are making different types of jewelry. Kindly support them. They are online. They are called Standing on Beadness. But please, before we go, we have people showcasing there, including our students, the first years who are making beads. Please make sure you go with something. That's a very good use of their talent. Let's clap for them. And tomorrow I will check whether we pass there. You see the ring? It's still beautiful, right? So let's promote them. So I like us. All right, so I'd like us to end there and request that tomorrow we start early, 8:30. Can we make it at 8:30? We finish on a high note. Tomorrow is the last day. We're going to have our communique and say what is it that we are getting out with from this conference. So let's start at 8:30. We have distinguished guests joining us tomorrow, and we do not want to start late and then we drag the whole program. So kindly let's start early tomorrow. I'd like us to pray. Let's stand. Let's all stand. We pray. And we are all going to pray together by saying these words. So let us pray. O God of all creation, bless this our land and nation. Justice be our shield and defender. May we dwell in unity, peace, and liberty. Plenty be found within our borders. Go well. Good evening.